There's apologies from Sydney Anderson and other members. Jim Wells will be late today. Item 2 is draft minutes. If members are content that they're accurate, they're on pages 5 to 12, and I'll sign them accordingly unless there's any amendments to be made. Right, agreed. Matters arising. There's 2 items of correspondence which has been tabled for members' information on the back of a number of the evidence sessions from last week. I'm going to move. We're just getting the first evidence session prepared, so let me, if members are agreeable, go to the more routine matters first, and we'll go to the correspondence section and we'll deal with that. There's 6 items, pages 517 to 576, and then there's 2 items at pages 9 of the table pack. Item 4 of the meeting folder is correspondence from the Committee for Finance and Personnel, which provides a copy of the terms of reference for its inquiry into flexible working in the public sector in Northern Ireland, requesting that the Committee obtains information on how flexible working practices are being applied in the Department of Justice and any good practice cases. So if members are content, we'll forward that request on to the Department for Justice and ask for that information, which then we'll agree to forward on to the relevant committee. Item 6 is correspondence from His Honour Judge David Smith, and he has provided a copy of the report of a 10-year review of the Rapid Assessment Treatment Service for drug and alcohol misusers following the informal meeting that he had with committee members last June. The report has now been placed in the Assembly Library, and if members are agreeable, we'll also send a copy of it to the Minister for Justice and the Probation Service for comments on the benefits of the programme and the position regarding funding of the programme in other parts of Northern Ireland. Okay, agreed. Item 1 of the table pack is correspondence from the Minister of Justice regarding payment of an environmental allowance to the post-2002 operational prison grade staff, as had been recommended by the Prison Service Pay Review Body. The Minister has indicated that the Service has identified the resources necessary to fund this payment in year, and it's envisaged that staff will receive payment backdated to the 1st of January of this year in their salaries at the end of February. They're now in consultation with the Prison Officers Association in relation to future funding of the allowance in the context of the 2014 pay round, and this is something, members, that we had asked for a number of weeks ago to get clarity as to how this was going to be funded and when, so we've now got that information. Item 2 of the table pack is correspondence from the Committee for Finance and Personnel, which provides a briefing paper from the Department on the 2014 Budget Bill and an accompanying spring supplementary estimates. Annex A of the paper sets out the reconciliation between budgets and estimates for each department, including the Department of Justice, which is relevant for the supply resolution debate, which is taking place on Monday next week. So if there's any other comments around the correspondence, we'll agree to action the remaining items as outlined in the meeting pack. Agreed. Chairman's business. The clerk has written advising that the whips have agreed that the Justice Committee meeting will be moved to a Wednesday afternoon for the duration of the roof project. The meeting will take place in room 21, and work is due to begin to install full broadcasting facilities. There's no definite date yet for the commencement of the roof works, although it's likely to be early March, and members will be kept up to date as those developments make some progress. I know it's going to cause some upheaval for members, but nevertheless we are where we are, and we'll have to adapt.
I actively welcome it.
Because you're open with us.
I know it doesn't suit others, and it doesn't suit some of my own colleagues, and I know other members it's going to impact on them as well, so I appreciate that, but we handed it over to the whips so I can do a Pontius Pilate and wash my hands off it. Nothing to do with me. Is there any other business that members wanted to raise at today's meeting? Well then, let's work our way backwards then, and we'll work through the item 12 of the agenda was assessment of the second annual report of the Interdepartmental Ministerial Group on Human Trafficking and the Anti-Trafficking Monitoring Group's follow-up report. Pages 344 to 515 has the relevant papers. At our meeting on the 7th of November last year, the committee considered the second report of the UK-wide Interdepartmental Ministerial Group on Human Trafficking. and that provided the assessment of human trafficking in the United Kingdom over the 2012 period, including the scale of the problem, trends, emerging threats, criminal justice response, and the strategic response to it. It also covered the specific work for child victims of human trafficking and progress against the action since 2011. The committee noted the department was considering the issues raised in the report with both statutory and non-statutory partners through the Organised Crime Task Force, Immigration and Human Trafficking Subgroup, and non-governmental organisation engagement group on human trafficking, and we agreed to request a written update on the outcome of the assessment of the report. That has been provided now to the committee with comments and suggestions received in relation to the report, the department's response to each of the issues raised, and the department has also provided details of feedback received in relation to the Anti-Trafficking Monitoring Group's follow-up report, Hidden in Plain Sight 3 years on, the updated measures to protect trafficked persons, and that was published in October last year in response to the issues raised. So it's there, members, to note, and obviously there's some useful information that members will be able to avail of as they consider the bill that's before us, and you'll see some of the issues that have been raised by the different stakeholders within that report. So if members are content to note that, unless there's any more information needed in respect to it. Okay, noted. Well, let's go to back on to the agenda item, which is item number 4, and we've got Mia De Fiche. I'll allow you, Mia, to correct me on that whenever you come to the table, but you're very welcome. For members' benefit, tab 1 in the bill folder has a copy of the written submission that was submitted from Mia, and it's at pages 16 to 18 of today's meeting folder. So let me formally welcome Mia to the meeting, and just to let you know again, it'll be recorded, it'll be published in due course, and I'll hand over to you to make an opening statement, and then members, I'm sure, may have some questions, but you're very welcome to today's committee, and we appreciate the time that you've taken to come to speak to us.
Thanks for the opportunity. May I just get a
Please
mouthful
feel
of
free.
water first, please?
Yep, by all means, settle there, and whenever you're ready.
My name is Mia De Fiche, and I'm a survivor of prostitution and drug addiction. I'm an activist in my own right and one of the many partners which make up the Turn Off the Red Light campaign. And I have given public lectures on the issue and used the avenues of media to highlight the harms and dangers intrinsic to prostitution and the reasons why the recommendations made by our own Justice Committee now need to be implemented. I am a second-year student at the National University of Ireland, Maynooth, where I am reading both philosophy and sociology. I'm also a mother of one daughter, and I have 2 beautiful granddaughters whom I adore. My decision to enter prostitution seemed to me at the time quite a rational one. I had developed a heroin problem at the age of 33, having never taken a drug in my life before. My partner had an even bigger drug problem. My money was gone, crime was not an option, but I knew I had a valuable commodity, for I had a female body which I could sell. It wouldn't be for long, just until they were sorted, I was sorted, etc. But I had made that decision while addicted to a mind-altering substance. And you don't make good decisions while trapped in addiction. And so I entered a paradox from which very few women escape. I'm one of the lucky few. Life on the street is so complex, as we led quite difficult and complex lives, that I would never be able to explain them in this short space of time. But there are 2 issues I would like to address. The first one of these issues is rape. Rape does become part of the job, so much so that we don't really use the term rape. We don't have permission to. We might alert to it, but then it's ignored and the subject is changed. Many become desensitised to the pain of others, because if you acknowledge someone else's pain, you may just have to acknowledge your own. And we don't have anywhere to place or deal with that pain. So some bury it, some use substances to forget it, some disconnect from it, and unfortunately, some accept it as routine. Every prostituted woman has a rape or sexual assault CV, and here is mine. It was December. It was freezing cold. We were more than usual out because it was close to Christmas. I got an offer of a job with a friend of mine, Jenny. It was for a Christmas party. She She said there would only be a few men, that she knew one of them well and we'd be fine. I was a little naive, as I'd only been on the Burlington Road for 5 months, and the thought of getting one large sum of money meant I would not have to come out again until after Christmas. So I went. It turned out to be 10 men in total, 8 men in total. I was nervous now, but we agreed the terms, what was allowed, what wasn't, etc. We were paid in full and we got on with it. There was alcohol and cocaine offered. I took cocaine, but I had no alcohol. So you can imagine what went on. Not all of the men wanted something from us. I did feel somewhat in control, but was aware that Jenny was getting drunk and the men were as well, and getting loud. When the time was up and we were left alone for a minute, I collected my things and told Jenny to get ready to leave. I went into the other room and said, right guys, we're going to go, and thanks, or words to that effect. I could feel something that changed the atmosphere. You could feel it. The hairs at the back of my neck began to stand up. One of them said, you're not going anywhere. We're not finished. I tried to reason by saying, come on, fair's fair, but I looked at the door and glanced in at the bedroom where Jenny was still not ready. I couldn't just run and leave her. The next thing, my hair was pulled and I was pushed over the sofa. And then it began. I was dragged back into the bedroom where myself and Jenny were subjected to an unimaginable horror. We were raped, mostly anally and orally. We were like rag dolls, not even. We were just objects to be passed around. My skin was crawling, my insides felt like they would come right up my throat. I wanted to scream, but I couldn't. I looked at Jenny and I couldn't protect her. She was much younger than me, much thinner and weaker. I looked at the man who was on top of me. I looked straight into his eyes. I thought, can't you see me? Can't you see my tears? And I will never forget the eyes that looked back at me, for they were blank. He looked straight through me. They tried to insert objects inside of us. Jenny was placed on a chair. I'm sorry I cannot speak about what happened next, but eventually it ended and they left. Thankfully, they didn't take the money back so we could get out of there. I picked Jenny up, half-dressed her and myself, and we left. I left that building with a bruised body and face, smelling of urine and bleeding from my rectum. Do you now understand how I couldn't see the choices anymore? I have never seen the world the same way since that night. As for my friend Jenny, she died. Her drug use spiralled out of control and she died alone of an overdose about 3 months later. It might have been heroin in her arm the day she died, but I know what really killed her. Today I am her voice also. My next rape was a year or so later by a lone offender off the Burlington Road. The next, I'm not sure if I can call it rape. It happened the same night. I was sitting on the ground on the street after the attack. My money and my phone had also been taken, just sitting disorientated and alone, with an aching body and a struggling mind. When a regular of mine pulled up, he got out of the car, picked me up and offered to drive me home. I told him what had happened and he stopped and bought me a coffee. But just before we reached my home, he pulled in and reminded me that I had no money to pay him. He was a taxi driver, but that I could sort him out. I didn't even argue. I just leaned back and let him. So what do you call that? Someone who has sex with a woman they know has been raped about an hour or so beforehand. My last rape was by 2 young men high on cocaine. One watched while the other did it, but to me he is just as guilty. I have countless accounts of humiliations, being urinated on, etc., of oral rape. In fact, I have no gag reflex. The muscles at the back of your throat learn to relax. They have to. I'm devoid of sympathy for buyers, as they messed around with the minds and bodies of some of the most damaged women I'm ever likely to come across. And they were my friends, and I cared about them, and I missed them. But at the same time, vengeance is not mine, nor is it something I seek or desire. I have long since let go of the fact that my rapists and abusers will never be brought to justice. In fact, it is something you must do in order to survive prostitution. I believe that why some people struggle with Clause 6 is because, for the most part, the men who buy human beings for sex are good citizens, in that they are in gainful employment, they pay their taxes, they pay their rent, they buy homes with their partners, they have 2.4 children, they tick every box that society deems to be correct, so we allow them this little indulgence. How do we allow it? Again, through silence and keeping it legal. For the men who bought me and all the other women, the men that feed this twisted industry, they walk among you every day. They are fathers, husbands, colleagues, etc. We don't want to acknowledge that the good citizen can behave like a bad human being. I understand that fear, but we hate to upset society's little apple cart. But at whose expense do we do that? I, on the other hand, would be viewed as a bad citizen. I didn't have a job. I was supported by the state. I was a heroin addict. And worst of all, I stood on a public street displaying my wares, luring these good citizens to me as if they had no choice. But I am a good human being. I always have been. And this is the balance you must find between the good citizen and the good human being, and which one of us comes first in the queue for protection. People ask me how many men. I was bought by 4 to 5 offenders, 2 to 3 nights a week, at least 45 weeks of the year for nearly 6 years. And that is an equation I will never do in my head. I was no sex worker. I was the trapped mind who lived in a body that no longer belonged to me. In fact, I was a disconnected, drug-addicted, walking rape victim. We all were. How our trapped minds cope depends on a wide range of things, too complex to explain briefly here. You see, prostitution, it is like inception, and it messes with your mind. I knew women who used their real names and would defend their position. To me, this was frightening, because it meant that they had lost all realistic hope that this could change, and had begun to find a sense of value in their own exploitation, contented acceptance, fueled also by the master manipulation of buyers. I believe that there is a fundamental difference between choosing to become and defending what has become of you, and the wise researcher gets and understands this concept. We learn and pick up survival skills. We use laughter as a coping mechanism. We only trust each other, for we know what the world thinks of us. Those messages come in loud and clear, and there are no messages that we are ever welcome back. We have become the worst insult a woman can call a woman, or a man can bestow on a woman. We sign a social contract that comes with the highest cost. For the small print of this contract, the terms and conditions are harsh, disturbing and unjustifiable. So it would appear to most that we stand free on the street, and yet everywhere we are in chains. Prostitution and sex trafficking are intrinsically linked. You have one because of the other. The last 18 months of my time on the Burlington Road, I stood alongside a trafficked woman. She became my closest friend, and I have never seen a human being so broken down. The conditions under which she lived were so inhumane. And although we had arrived at the same place through different means, we are connected because we were bought, used, exploited, humiliated and raped by the same offenders. One night I would be bought, and a few nights later the same man would buy her. And on a couple of occasions we were bought together. That connection can never be broken by anyone at any time in any country. There are some who would argue that one has a right to do with their body what they wish. I do not see this as an absolute right, because if what you do with your body, if by doing it, promoting it, feeds into an industry which is at its worst, results in the rape and sodomization of children, then no, it is much more of a limited right. But what I do believe is an absolute right, as stated in the Declaration of Human Rights, Article 4, slavery and servitude in all its forms must be prohibited. We must always remember that the liberty of a few should never come before the freedom of so many, because any time in history that has happened, human dignity has been removed and freedom lost. I never describe what Sweden did 15 years ago as a model. To me, they set a remarkable example to which I believe Europe must now follow, and as we know, 3 countries already have. But it comes as no surprise to me that it was Sweden who set this example, because as the most equal society in the world, Sweden was in fact the only country where the reclaiming of human dignity could have begun. Sweden placed human dignity first. They fully understand the concept of human dignity, which is the value and respect we place on one another as human beings. What happens when we place human dignity first, as Sweden has proved beyond doubt, is that the good triumphs, whereas in countries where it is placed last, evil thrives, as is abundantly evident in the countries that have either decriminalised or legalised and the tolerating regimes. That evil is both human trafficking and the place where vulnerable women and children are trafficked into, which is prostitution, where they join the addicted, disconnected and damaged women like myself, who are also trapped but in a different way, to service the needs of a particular group of men. Arendt concluded that most evils in the world are committed by nobodies. I agree with her. And furthermore, I believe it is now time that the nobodies were brought to bear and made accountable and responsible for the cruel industry and the slave trade they willingly sustain and uphold. In fact, it only exists because of them. Once again, Sweden did not do a radical thing nor a controversial thing. Sweden Sweden just did the right thing in the name of freedom, justice and equality, and now it is the turn of our island. I believe we have a remarkable opportunity to evoke a social change for the greater good, an opportunity which we must not allow to pass us by. Committee members, I have 2 beautiful granddaughters, and I want them to grow up in a country, on an island, and in a Europe where the bodies to which they have been born into are respected, and in no time will they be up for sale like their beloved grandmothers, as is my wish for every little girl. The one sure thing that nearly 6 years of sexual exploitation taught me is that prostitution is not compatible with humanity, and we either choose one or the other. I implore you to come to a wise choice.
Thank you very much. I know for members we've had a number of evidence sessions where I think it's difficult for all of us, and this is another one, but it obviously doesn't come anywhere near as difficult as it has been for you. And I want to thank you for coming to the committee and appreciate your honesty and the way in which you've conducted yourself before us. Obviously, members will have some questions that we need to ask to do our job right in terms of scrutinising your evidence, and I hope you appreciate that. And let me first of all start with a couple of questions, and then I'll open it up to members to proceed as well. First of all, I was struck by your testimony when you talked about being raped. At any point, did you contact the police?
No, it's not something that you even think of. It's calling the police. Like I said, we don't know if we can call it that. We know it is, but it feels like you don't have. And it's hard enough for women who are outside of prostitution to take rape cases again. So it wouldn't even, because the first thing that would be brought up, a lot of people don't even believe a prostituted woman can be raped. So it doesn't even enter our heads to call.
When you were talking about the particular case that you highlighted with Jenny, you said that you looked into the man's eyes and he just looked through you as though you didn't exist.
Yeah.
Was that the typical experience?
See, rape and sexual assault it's because you were bought. So someone has purchased an object, and if that object is not functioning as they requested, and they have considered that they have paid good money for this object, so what happens is it's like when you buy something and take it home and it doesn't work properly. You know, the first thing many people do is shake it. Same principle applies in prostitution. You know, I've bought you to do this, you're not doing it properly, so I'll just, I'll shake you. Because you're not seen as fully human. You have been bought to do this, you don't do it properly, I've get paid good money for you. So in a way, in prostitution, the conditions are set up for rape to happen, where you have good citizens that maybe outside of this would never have. But when those conditions are set up, it's more possible. And a psychological study after study proves that if conditions are set up, and human beings are in fact capable of anything. So that's the problem with sex, which is why even independent women carry personal alarms, and legal brothels have panic buttons, because you cannot predict that, you cannot legislate it, because it's, do you know what I mean, when the person who's bought you, what way they're going to react. You can learn that there are signs of when you feel not safe, but that depends also how much drugs in your system, how aware you are, how cold you are, So, but really the conditions are set up for it to thrive and to happen.
Well, so, some of the witnesses that we've had before us have said that their clients, as they would call them, cared for them, that would be concerned for their welfare. In your experience, did the men care for your welfare?
I mean, not every man that bought me was violent or abusive towards me, but part of me feels that I just refuse to feel thankful or grateful just because they didn't. You know, some think they care, but like the regular of mine, he'd never been abusive or violent towards me, and he picked me up off the ground in a terrible state. But I didn't get out of that car without servicing his needs. So he would justify his action, maybe because he showed me a kind act, you know. But the very fact that they come and buy, I mean, they're all aware that we are not standing out on the street because we have functional lives. I only ever met one woman who wasn't addicted to alcohol, drugs, different kinds of drugs, or had underlying psych issues, you know, and they know that. And in fact, the more vulnerable you look, the more popular you are, because it isn't about sex, it's about power.
It wasn't clear from some of the notes that I read just what age you were whenever you started.
33, when I got addicted to heroin, and I worked briefly on another street, Benburg Street, but I was on the Burlington Road from early 05 to the 10th of October 2010. Last night I stood on the street.
So during that period of time, I suppose what we're particularly interested in as well is how much of people that are involved in prostitution are victims of human trafficking. From your experience, what's the prevalence of human trafficking, and if you can also let me know what age would some of the girls be? Would there be any minors that would be involved as well? So if you can address those 2 points.
Sure. Most of the trafficked, coerced women are indoors. The woman I knew was not, obviously. She had been 10 years. She'd been taken out of Africa 10 years beforehand, and it began in Greece, Switzerland, the UK, and finally in Dublin. But it took me a long... In fact, the reason we got close was I heard her speak a language, and I had been to that part of Africa some years before, and that was why we got close. But her trafficker, controller, watched everywhere she went. He would patrol the street. She was sent out at 5 p.m. and worked continuously till 5 p.m. a.m. the next morning. She had to return with every €100. She was addicted to crack, and he was the dealer. He barred her from speaking to me. He couldn't stand me, and not because, you know, I could get her to work for someone else or I could get her off drugs. He couldn't stand me because I treated her like a human. I was the only friend she'd had in 10 years. I reminded her of her children at home when I spoke of mine, and that was the thing that could have taken her from him, humanity. I challenged him once, and he walked away from me, and it was quite eerie. But how he sent the message back to me was he beat her and sent her down to me, and she defended him. She had this loyalty to him. You know, I understand now that it's trauma bonding, and women kept in those conditions can get this attachment to their controllers or traffickers or pimps, and she would defend him, and I couldn't understand. And I took her to my home once after she had been And I described it in the submission, you know. And I thought if I got her out of the country, if I got her home, just get her out of the country. But I had no understanding really of that bond that these women who have been under that much control and constraint and abused form with their abusers. And even as much as I loved and cared for her, I couldn't break it. And she would turn to him.
The age profile of some of the other girls?
I never met anyone, a young girl under about 70. I know 2 or 3 that were 18, 19. I never met 14, 15 on the street. And I really don't know what I would have done, because I had a daughter the same age at home. I mean, the 18-year-olds I knew, I don't know exactly what age they were when they entered, but when I went down the street, you know, they were. And then it went up to, there were a few older ladies that had been 20 years on that street. One woman, she said one night, "I'm retiring." And I remember looking at her and thinking, my God, is that me? 20 years? It was just so strange. But the street is it's different. There are rules on it. There's a hierarchy. You know, it's quite a complex place to be. And in some ways, like normal group dynamics, you know, the older ones would be shown respect, and the younger ones can be quite chaotic, because crack cocaine is quite unpredictable, behaviour is quite unpredictable, and they put themselves at much more risk. I can't tell you how hard it is to watch, as a mother of a daughter, to watch an 18-year-old get in the back of the car, and then she comes back and she's not quite sure exactly what happened, you know. And one night there was one of the younger ones, she was thrown out at the back of a van, but she knew the man had inserted something inside of her, and she felt like something was still stuck, but she couldn't get it. And to myself and another girl, we had to help her, and I had to physically take it out. I can't tell you what it's like to hold an 18-year-old in my arms that I couldn't send home because she hadn't got one. You know, couldn't ring her parents because they weren't around. You know, I watched her cry, and all we could do was give her money so she could go and get something that would numb it all. She came back about 2 weeks later, and she was so angry. Oh, she owned the street. She fought with everybody. And I thought, God, you know, is it anger, or is it just, you know, a child really, so damaged and hurt and humiliated that she doesn't know where to place that. So she comes back angry. You know, it's quite a cruel world out there, and the way you cope with trauma and the survival skills depends on a number of things, and you know, but it's quite hard to witness, and yes, we laugh a lot, but laughter becomes, because if you got angry, you'd be afraid how angry you would get, and if you cried, you might never stop, you know. So laughter is this kind of release, and we laughed at some of the strangest things, you know.
Finally for me, and then I'll bring other members in, Clause 6 and the criminalisation of the buyer. Sweden obviously has pioneered this, but it hasn't stopped it.
Yeah.
It hasn't stopped prostitution, and it hasn't stopped trafficking. Now, the evidence we had is that it has reduced it when we were there, but it's still there.
Yeah.
So what
do I say?
What makes you believe that the criminalising of the buyer would have an impact here both in Northern Ireland and obviously if the Republic was to do it, in terms of what you've told us today and reducing the problem?
Well, firstly, I don't believe, personally, that anybody has a right to buy another human being to do with their body what they wish. So I think that should be in law, regardless. Sweden's figures speak for themselves. And no, it hasn't been abolished altogether, and it probably never will be wiped out completely, and that is because there, in this world, we will always have people who take advantage of the vulnerable, you know, who make profit over on the backs of other human beings, and that is because no one, not even Sweden, the most equal society in the world, has found the cure for the human condition and all its complexities. That doesn't mean you don't do anything.
Thank you. Ms McCauley?
Gurra Mai Carly, thank you, Chair, and thanks for your presentation. And it must have been really difficult for you to talk about that, and it's been what probably the most horrific thing I've heard in all of this. And I'm wondering about how you managed to exit the life that you were in there. And I mean, if you wouldn't mind maybe telling us how you did that. And
sure.
Was that unusual for someone to exit?
In the end, I didn't kind of decide one day I'd had enough, or my daughter had battled an illness and she had become quite ill, and I had to get some inpatient care. And while she was there, she met a social worker, and she took to her. My daughter would be quite guarded, as we had lived quite an isolated life. You know, I was home all day minding her, and I left to go to the Burlington Road 3 nights a week. But apart from that, it's just us. And anyway, she let her in, and that social worker asked me to come into her office one day, and which I did with the usual guarded front. And but she asked me a few questions nobody had ever asked me before. She asked me what was life like for me, and what was it like to be out there all alone, and what was it like to be a mother and watch my daughter fade, and you know, feel helpless. Nobody had ever asked me those questions, you know. I'd only ever met judgment, and people presumed, you know. So anyway, I began to talk to her. I spoke to her every time I went out, and I trusted her. I told her things I hadn't told anybody. I let her in. So when my daughter was well enough to come home, she asked me if she could make, did I trust her enough to make 2 phone calls on my behalf? And I said yes. And she rang. I had previously worked for the health board for 10 years, and 8 of those years was in as administrator to a detox unit for heroin users. And she rang my former boss, consultant psychiatrist, and she met me, and he made the decision. He rang me and said she will be going to rehab here, St. Michael's, and onto the Rutland. So even in the end, I didn't make that. She could see choices, I just couldn't. You know, because I don't know, my choice might have been a much darker one.
So it was rehab then?
Yeah, so I had a medical detox for 3 weeks, and then I spent 5 weeks in the Rutland, and then I had severe post-traumatic stress, and I had suffered disassociation after the gang rape, where I viewed the woman I was at night, Lucy, as separate. So I had to conquer that, and it often involved 2 people and a chair for Lucy, so that I could own all of that and, you know, find myself again, because it was like a 7-year war was over and I didn't know who I was. But I now know disassociation and all that is quite common, and I read a lot. about trauma and how to recover. And then I went to Ruhama, and I really haven't looked back since Ruhama. I knew education was the one thing that would save me. It's the one thing that pull people out of adversity. It's the one, and for the most part, the very lack of it is why women will end up in prostitution. So.
And have you been able to maybe go to some of those people who lived that life that you were in to show them how they can escape? I work with the anti-trafficking office in the ICI and with Ruhama, but mainly I have just been, activism to get this law for ourselves and now here. So I have given my insight of the story to a couple of researchers who are, I wouldn't, I couldn't go back to that street and offer, it would be too close. It's only 3 years since I walked out there. My friends are still there, So I give my insight to the people who know what to do with it, whether policies or care services. And maybe one day, but for the moment, I couldn't go out to the front line as such. And you were saying earlier that nearly everybody has got an addiction. They're very complex issues. I mean, you said you had an addiction to heroin, and you were saying about other addictions. Would most of the women that you met have addictions like that? Those kind of very complex
well,
issues?
only one didn't that I met. The older women tended to be alcohol, and the younger ones, it was crack, heroin, and really anything that was going, and then there was heroin addicts, some more chaotic than others, but yes, and some it was alcohol, maybe speed, but it was all sometimes with tablets and it was what do they call it, polysubstance abuse, so it would be a combination of whatever.
And thinking about those people, those incidents that you described, can you see that those kind of people might be put off by purchasing sex, by Clause 6? If they were the type of people that can do those kind of things, do you think that would deter them?
Yes, I think
that's what I find difficult.
Yeah, it's the one thing, it's the only thing that will stop them. As one said to me once, I don't worry about the police, because as long as I get to the post before she does, I can pay the €50 fine. It's the only thing that will, it's the only, again, because I also believe it's the right thing to do. But it is. I know the men who bought me very well. I spent 6 years in their company. They're not men who are not watching this debate or not. Do you know what I mean? They're not men. They're not going to risk. There's a risk there. They have to be made accountable, and they know that. And it's the one they get away with it now. They've permission to do it from society. And once society and the government that is over it says no, then, but it really is the fine, and not a €50 fine that they get to the post box before, because they'll have to take responsibility. The only way you will change that behaviour, people's behaviour, is if you make responsible for their actions.
And what do you think the penalty should be? Say, if Clause 6 were introduced, what do you think the penalty would be then if someone was found guilty of paying for sexual services?
Well, obviously, it couldn't be, way. I know France is, I think it's €1,000 or €15 they're going to bring in. That's quite, Sweden, it's based on your income. We wouldn't have, we're not as up to date as Sweden for that, but substantially more than €50.
Okay.
But
so just one other thing I was wanting to ask you. if Clause 6 were to, I mean, and you've made your case that you think that this will be the deterrent, what about, it's a single clause, what about those women then and all of their complex needs and the issues? Where does it leave those women?
I'm often asked that, say, Mia, if you were still out there and if somebody came along and said, you know, we're going to legalise this and give you health, I would have thought you were mad. I would have said, look around. Seriously? You could formally make this, you know, legitimate? But anyway, if you had said to me, this is terrible, we're going to stop. Nobody's ever going to be allowed by you again. This is awful. I would have said, that's not what I would have heard. I would have heard, oh my God, she's about to remove what gives me access to the drug that keeps me sane. Because if you remove the drug, I will remember. You know, I won't be numb anymore. But that doesn't mean we don't do it anymore. It would have been hard. I would have been sick. But you know what? I would have had to reach out for the help that actually was there. But I just couldn't see it.
And I mean that point is fair enough. But you see that there are different views on how maybe you deal with the issue of prostitution, and you know, I mean, there's a view that just dealing with it with a single clause is not maybe the best way, and it needs to be looked at and needs to have, you know, an exploration of what is involved. And the way you've talked about those women, it certainly, you've made the case that you definitely have to look into what those lives are like and how do you address their needs, what are the health issues. So I think you've made a good case for looking at it in a very particularly comprehensive way.
Yeah, I mean, along with Clause 6 and that side, I am fully aware that we would need, those women would need support systems. And I'd like to see the money that comes from the fines placed directly into those support systems. Because for me, that's the very least they can do, is financially contribute to the repair of the damage that they have actually caused. So, but yes, I'm aware there are exit needs. There will be support that will be, needed for the women. Absolutely.
Thanks very much.
Mr. Humphrey.
Thanks, Chair, and thank you very much for your presentation and evidence today. May I have to say, I know it's a cliche to say it, but it is really powerful, and I have to say, very distressing, not just for you, but for those of us listening to it. And I think there is a huge responsibility on us as legislators to listen very carefully to what you've said and act on it. Can I ask you, in the course of the last number of months and evidence that we have received in this committee, you used the terminology that you were bought, or people came to buy. Other people have recoiled, that have given us, have recoiled at that terminology being used, and wouldn't agree with you. Why are you? I'm not saying you're comfortable saying it.
Sure.
Why are you using that terminology, and why do you think it is the appropriate terminology?
Because people tend to use the purchase of sex, but you can't buy sex on your own. Do you know what I mean? It is the purchase of human being for sex, because if when you came up to me and asked for a sexual act, I didn't take it out of my pocket and give it to you. You had to buy me and all of me, and I had to go with you, and all of me had to go with you. You always have to buy the person before you gain access to the body. So.
Okay. You also said that I think if I picked you up correctly, there was only one person that you actually came in contact with who was a prostitute who wasn't on either alcohol or drugs. Can I ask you directly, were alcohol and drugs required to see you through the day or the night?
Some of us had, for me personally,
the collective.
I would have been quite religious in how I used my heroin, as I had to kind of keep some sort of stability for my daughter. So I'd smoke 10 to 15 lines in the morning. I never smoked it before I went out to the street, because when you're in the early stages of withdrawals, your senses are heightened, and I felt safer being out there with heightened senses rather than taking heroin before I went, where you would be numb. But a lot of women take it before. Now, the minute I jumped in a taxi to get home, it was the first thing, that I took. But after, I would have only smoked 1 bag a day prior to the gang rape and disassociation, and that increased after that. So yes, I was taking more to shut out quite a few things. I couldn't say for complete, because we don't have conversations as such.
No.
But I do know some women do. Some women, if they've had a bad experience, go and get alcohol and come back. Some women earn £100, go off, get stoned, come back.
It could be part of the coping mechanism.
It could be, or sometimes it's chaotic addiction.
You used the term as well that it wasn't for those who are the buyers. It wasn't about sex, it was about power.
Yeah.
Can I ask you if you're comfortable enough to expand on that?
Yeah, well, I was thinking, in this day and age, given the access we have to the internet and what you can get, you can actually go online and meet someone, a consenting adult, no money, meet, whatever, go. There would appear to be quite a number of people, groups, couples, that are into all sorts of things, and you can do that without ever handing over money. So what are they buying?
We've also had some evidence from various groups and individuals who've come before the committee, or indeed on our visit to Stockholm, where people have said that women have a choice in this. And it is a choice that they make freely. Do you believe that?
I do know that there are a few women who say they're happy to be there and they are independent. And I have spoken to a number on occasion. And my issue is not... I still don't believe anyone has the right to buy them, no matter how happy they declare to be. But they are very few. And as I said earlier, the liberty of a few should never be taken before the freedom of so many. As I said at the start, I made what I thought was a rational choice, but I wasn't in the right state of mind, as nobody is in addiction. That's why rehab was invented, because we make messes of our lives and stuff. But the ability to see choices goes or becomes extremely affected by trauma and disconnection from society in general. A lot of the women I stood beside were second generation addicts, so this wasn't an unfamiliar place, addiction, dysfunction. In fact, some of them, it's just the only thing they ever knew, and if there was a quiet night on the street, all of a sudden there would be a fuss, because when you get used to trauma and that it can be something that you crave or you feel comfort, even though for those who aren't used to that, but really you lose your ability to see choices, and then for some women that choice was never there. It was like their life script was already written, so they didn't see it. Like, they would have considered me quite strange, and they were very protective of me, because they felt I shouldn't be there. I was respectable, educated, and they were extremely protective of me. But that didn't tell me that they felt I was a better person or whatever, it tells me one thing, and that is how little value they placed on their own lives.
A few weeks ago, this committee had a joint meeting with the committee in the Irish Parliament at the Dáil. Can I just ask you, during your evidence you said you wanted laws to protect women in Ireland, on the island and Europe. What do you think would happen in terms of prostitution if there were laws enacted in the Dáil and the Northern Ireland Assembly didn't follow suit?
I think some people will be travelling up north and not such. Yeah, because if we close it off to them, if we cut off their profits, their whatever, they will transfer their commodities to where they can legally sell them. And the next nearest place to us is England. You know, they will move, and France has closed its doors now, and they will shift to Spain. But you know, Israel's looking at this, Croatia's looking at this, and you know, it will move on. But we need to. So yes, it would be something you would need to take account of if we do one. I would like to see the whole of.
So the problem would be displaced?
It would be,
yeah.
Yes.
Okay.
Would be. It would, of course. You know, they don't. Sweden isn't attractive to them anymore, because why would they import women when it's illegal to buy them? Mm-hmm. You know, so.
Okay, thank you very much. Thanks, Chair.
Mr. Elliott.
Chair, thank you, and thanks very much for the presentation and the evidence. You did talk about support services and the potential of support for victims. How would you see that operating? I'm assuming you would need quite a lot of people on the ground as well, assisting those people involved in prostitution, and obviously the rehabilitation. Can you explain maybe a wee bit what's in your mind on that?
Well, in the South we have Ruhama is the only organisation that looks after women affected and exiting, and is while they're still in prostitution. So yes, they would need extra support systems to be put in place, and they look after the trafficked women as well. There's a number of things that need to be sorted that I know are in our recommendations, because the status, our definition of trafficking, the status, you know, accommodation, safe accommodation. So there are a number, but the recommendations that our Justice Subcommittee does allow for them and does bring them in, and they are.
And how much of that would you see would be the government responsibility, as opposed to agencies or voluntary groups?
I think it would be the government's responsibility to make sure the funds are available for it, because it has happened, because it has been tolerated. So,
can I ask, just when you were involved in prostitution, did you feel you were trafficked in any way? I suppose we're looking at the legislation here of human trafficking.
Sure.
And would you have said that you were trafficked in any way?
No, I wasn't trafficked. I would have a lot of Irish women. There's very few Irish women left in prostitution. It's minimal, and we tend to be on the street. But a lot of women on the street have their pimps come in the form of drug-addicted boyfriends or partners. I would have had a partner who never went to the street, but yet expected something to be brought home. And for a long time I would have been quite nervous, and I don't really know why. I look back now and think, God, why didn't I just... But you don't see that, you see, when you're there.
Okay. And do you believe if this legislation were to be approved and go through, that it would not only, because you have indicated how you feel it would reduce prostitution, do you actually feel it would significantly reduce drug abuse? Well,
well, in the sense that the women that are affected and they reach out for help, that is one of the, Ruhama and the organisations, they look at everything that's in the person's life, from whether there's court issues, children's issues, drug issues or whatever. So yes, that would be one of the things that would have to be tackled. So
that would be one of the, I suppose, the support services that would be required as well?
Yeah.
Okay. Thank you.
Okay.
Sure.
Okay, thank you. And Mr. Elliott made the point about, do you feel you were a victim of human trafficking? And I think that's a fair question. Probably sometimes we're in danger of thinking this bill's only about prostitution and human trafficking, although the bill's title is Human Trafficking and Exploitation. And I'm not going to ask the question, do you feel that you were exploited, because that's a silly question for me to ask, but it's just bearing in mind that it isn't just about human trafficking and prostitution, it's about exploitation. A couple of just final questions. One of the arguments that has been made against Clause 6 has been this could make it more dangerous for women because it'll drive it underground.
Okay.
What's your response to that?
You'll only hear that from one side because it is a fallacy. And the error in the reasoning of that argument is prostitution is not like any other vice. No drugs, guns. They need the underground. They only survive underground because it's criminals dealing with criminals. But where prostitution differs is that it only thrives and survives because of the good citizen, of the general public. So it will always need a face because it doesn't exist and there is no money to be made if you can't advertise. They need a face, they need a domain. So it can never, prostitution is the one vice that cannot exist underground.
Okay. In terms of the academic debate that rages around this issue, and people say there's statistics to say Sweden has worked, there's statistics that say it hasn't worked, and the ideological views on this is at times very, very polarised. What's your view of that academic debate?
I currently study at a university that in our sociology department we would have two academics who would differ to my opinion. Mind you, they've never spoken to me, even though they know I'm there, they know who I am. But I think it was clearly demonstrated here last week when their research is held up to scrutiny. It doesn't, stand up. Part of me, there's a lot of female academics who stand, and sometimes I don't have an answer. I will never understand women who fight to keep women in sexual exploitation, especially when they shout this out from the ivory towers of universities, places where the women I stood alongside, most part will never gain access to. So they usually put the argument for a woman has a right to do with her body, but I already explained how I feel about that, or they use the underground fallacy. I don't know, sometimes for the life of me I don't know, I don't understand their position. I don't know, but I can tell you one thing, you will get 2 or 3 of them in every sociology department, in every university, everywhere. But for every 2 or 3 you get, there'll be 4 or 5, 6 sociologists that would never take that position, as there is in my own.
Obviously, you've been very brave to give a voice to your particular experience. What has been the response from individuals, both that are currently in the industry, if you want to call it that, to you having stepped forward and spoken about this?
It's been mainly positive. I haven't received any nastiness or anything, any threats, anything. In fact, the couple of independent women I've spoken to, they have been quite compassionate. We still don't agree with each other, but there hasn't been any. I know I don't have any animosity towards them. It's about the right thing for the greater good and to combat the evil of human trafficking. So I haven't. It's been positive. I have good friends and good support, and great support from my lecturers, especially in the philosophy department. And I haven't. I keep very much myself to myself. I don't trust easy. I have a handful of good friends I wouldn't swap for the world. You know. So, but I haven't. It's been mainly positive, absolutely.
Good. The last point I wanted to make, and is to go back to one that Ms McCorley made, and I think some of us are struggling to try and grasp that if we have existing legislation that deals with coercion, that law is here in Northern Ireland, that if there's no defence at all, even in ignorance, if you've engaged in sex with prostitutes and they have been trafficked or they've been coerced into the industry, that if those individuals aren't concerned about the current laws that are there, and they're not concerned about you, and you talked about that individual that raped you just looking through you like you didn't exist, if they have no modicum of consciousness about them under existing laws, why then will this particular Clause 6 have any impact on them?
Because it makes them responsible, and the issue of fines that will be more than €50 makes them accountable. It brings it in, it puts them at risk of bringing what they do in the dark into what they do in the day. You get me? Mm-hmm. It's a big risk that I know most of the men who bought me would not be prepared to take.
Okay. Well, there's no other members, so again, can I thank you very much for coming to the committee. It's been a very powerful piece of testimony for us, so I really appreciate the time that you've taken to come to speak to us. Thank you.
Thanks for having me.
Not at all. Okay, members, thanks for that. We will move into our next item agenda, which is the briefing session with the Attorney General. We agreed at our meeting on the 16th of January, members, that we would invite the Attorney General to today's meeting, and so that we can discuss the issue around Section 8 guidance and whether or not the PSNI should be added to the list of which this guidance could be applicable to, and individuals at some issues that they felt Mr Larkin may be able to illuminate for them. So can I formally welcome the Attorney General for Northern Ireland, Mr John Larkin QC, to our meeting, and as before it'll be recorded by Hansard and published in due course. So let me invite you to make some opening comments, and then members will have some questions.
Thank you very much, Chairman. Once again, it's a pleasure to be before the committee as it goes about its consideration of this issue. Members will recall that I was previously before the committee and drew this issue to its attention and invited the committee to consult. The committee did so, and important responses were elicited from the police and from the policing board, and in the form of fairly full letters from the Deputy Chief Constable and from the Chair of the Policing Board. I've seen those, I've had the chance to consider them, and I've replied offering some observations on them, which I hope are of assistance. I know members will have been issued with the relevant correspondence, so I would propose really to repeat what is in my last letter to you, Chairman, which members have had a chance to read. Safe to say that there's no question of usurping any of the important functions of the policing board with respect to its monitoring, with respect to human rights, particularly under the Human Rights Act 1998. I would see this as complementary and additional, and that there is no stepping on the toes of the Policing Board in any way whatsoever.
Okay, thank you very much, Mr. Larkin. To members, there were some people who wanted to ask some questions, and I want to make sure we use the Attorney General's time productively to get to the bottom of that. You've highlighted to me the appropriate point, which is this doesn't take away any powers the board has, which I think was a concern in the correspondence that we were being copied into, and certainly I'm satisfied with the responses that you've provided in respect of that. At this stage, just for clarity, this is to purely add them to the list.
That's right.
There's obviously would be a process to say, here's now my guidance, what do you think?
That's right.
Okay.
If it's of assistance to members, I'd indicate that that's absolutely, as you've said, Chairman, it's about adding the name to the list. It doesn't add any particular guidance. The first piece of guidance that I would wish to produce for PSNI would be simply to give them the benefit of the right to life guidance, which already exists for the other criminal justice organisations already included within Section 8.
Okay, members, any questions? Mr. Lynch?
I have read, thanks for coming to the meeting, Attorney General. I've read the Deputy Chief Constable's letter, and she has outlined the framework, the human rights framework, and she thought it would suffice. So where do you, and I haven't read the letter to the Chair, where do you feel there needs to be your own oversight?
Well, let's take the piece of guidance that's been produced already with respect to the protection of the right to life of members, employees of criminal justice organisations against the acts of third parties. That's at present not contained within the Code of Ethics, nor could it be, but it can be provided in the guidance. And, for example, the powerful topic that you were discussing just now draws attention to issues about human trafficking. There is, of course, a convention, as members will know about that from their extensive consideration of that issue already. That's not part of the Human Rights Act or the European Convention on Human Rights. That's something to which specific guidance could be given by way of concrete illustration. Another factor, of course, is that the Code of Ethics is self-contained. It doesn't relate to the exchange with other organisations. And if we take, for example, a very important obligation that all component parts of the criminal justice community are subject to, and that's the need to avoid delay where it's possible to do so. One of the useful functions of the guidance will be to ensure that there is, as far as possible, seamless cooperation between the various criminal justice organisations in order to achieve goals that are common to all of them.
Yeah, Chair, I understand your reasoning around other agencies like the Forensic Science Laboratory, which has no oversight, but the fact that the police have fairly robust oversight in the context of human rights would seem that you're assuming more power.
No, because the obligation that's on the police at present is that under Section 6 of the Human Rights Act, which applies to all public authorities to act compatibly with the convention rights set out in Schedule 1 of the 1998 Act. But all of the existing criminal justice bodies are already subject to that, and that the monitoring that takes place of the police service is confined to that. This, in addition, brings into play other international instruments.
Mr. Picardo?
Have you met the PSNI or the Policing Board in relation to this?
No, as I explained on the last occasion, I, as in previous occasions, sort of rely upon the committee to do that. Now, let me make it absolutely clear. When it comes to the actual construction of the guidance itself, there's always extensive consultation with the particular criminal justice agency involved. So if PSNI were added to the list, there'd be no question but that any guidance would be discussed with them extensively in advance, even of it being brought to this committee, for example.
But the committee now has no inflicting weight put on the need for this. So would it be useful if if you met the PSNI and these issues were possibly resolved without us being left in judgment, so to speak.
It's quite proper for the committee to be in judgment. But yeah, I think that my letter, you may say, of course, that I would say this, provides an answer to those points. I can see from the legislation itself that the existing obligation of the police service and of the policing board is both to respect and to monitor with respect to the Human Rights Act 1998. Section 8 relates to all relevant criminal justice standards, so it's a broader range of obligations, and it's capable of cutting two ways. The Code of Ethics applies to the individual to whom it's addressed. If I say so, the important thing of the guidance, it moves in two directions. It obliges both the organisation and the individual. Hence, to give one example which I hope is helpful, the protection of the right to life of members is addressed as much to the management structures and the organisation corporately as it is to the individuals who have responsibilities one for another.
And once the guidance is issued, what role do you have then?
The guidance, as you'll have seen from the guidance that's been made thus far, the guidance contains within itself provision for monitoring and indeed for early report by the organisation if it finds a problem with the way it's working. And so far I can tell you that no organisation to whom guidance has been addressed has identified any problem with its operation.
Thank you.
In terms of that monitoring of the guidance, who does that?
I do it in association with the organisation itself. So there will be a structured review after 1 year, and organisations are encouraged, if they identify problems with it, to draw it to our attention before then.
And just to be absolutely clear, if we were to agree that this should be added to the list, ultimately you would still list the committee to sign off on the guidance.
Absolutely.
That's the way you've handled all of the other
That's right.
agencies, that this committee has had to approve it.
That's right.
So there's
it's a double lock.
Yeah.
But the first thing is this permits guidance to be considered effectively. It doesn't itself produce guidance.
Okay. Mr. Elliott?
Chair, thank you, and thank you for the presentation. The Policing Board Performance Committee said it was unnecessary and unhelpful. You went somewhere in your letter to actually explain the reasons why you think they should be included, but you haven't addressed those 2 points that they're saying it's unnecessary and unhelpful.
Well, I think actually, if you look at the letter closely, I have, because it draws attention to the nature of the obligation that's on the Policing Board, which is confined to the Human Rights Act 1998. The Section 8 reach is larger. Now, on one hand, that could be sort of potentially viewed a little bit alarmingly as bringing to bear a whole range of obligations, but I think helpfully, at least I hope helpfully, the committee will have seen the guidance that's been produced thus far, which is very practical in its nature and designed, as I said before, to reassure competent and conscientious professionals in their particular criminal justice disciplines that they're acting safely and in a way that's consistent with the highest international human rights standards.
You refer a number of times to the 1998 Human Rights Act. Are you suggesting that there is actually an onus for the police to be included under that Act in this?
No, well, the police are already, by Section 6 of the Human Rights Act 1998, subject to the full range of obligations. For example, the Convention Rights are set out in Schedule 1. But the point that Mr. Elliott makes is an important one, because I think it's actually clear that the grain of Section 8 of the 2004 Act really almost implies that the police should have guidance that's relevant to them, and yet they can't have guidance that's relevant to them unless the name is added to the list, the name of the organisation is added to the list. And I say that because when drawing up the Code of Ethics, the police have to have regard, the Chief Constable has to have regard to the content of any guidance, and yet there can't be guidance unless PSNI is added to the list.
Quite interesting, Attorney General. You use the words almost implies. quite unlike you, you're usually quite definitive.
Well,
and I'm wondering, it either doesn't apply or it doesn't apply.
Well, I'm not going. If I answer your question by drawing attention to two individuals two bodies that I've consulted, the Advocate General for Northern Ireland, Her Majesty the Attorney General, supports the addition of the PSNI, and the Police Federation, in terms of a body with practical experience, also supports the addition of PSNI to the Section 8 list.
Okay. Finally, is there any European legislation that may apply?
Well, not legislation.
Or directive even?
There is a range of international human rights standards that apply, and some of them are referred to, for example, in the letter.
Thank you, Chair. Thanks.
Okay. Mr. McGuinness?
Yeah, thank you very much, Chair. Attorney, you're very welcome, and it's a useful conversation. But at the end of the day, I suppose what we're struggling to gather is what added value is there in relation to your proposition, in relation to the PSNI. PSNI is subject to the Policing Board, subject to the Human Rights Act, subject to the individual officers, subject to Code of Ethics, and there is a range of legislation to which it must act in accordance with, and in accordance with human rights standards which have been well established under the jurisprudence, the European Court, and so forth. So, I mean, what additional value is there in what you're suggesting?
Let me give an immediate practical example,
Yes.
and also set out a larger sort of theoretical example.
Yes.
The practical example is very easily given, and it's the extension to PSNI of guidance which every other criminal justice organisation has the benefit of, and that is the protection of its members against threats to their life and well-being from third parties.
Yes.
So that is the kind of document that can't be contained within a code of ethics. It's addressed to the organisation corporately to see that it discharges a range of international human rights obligations with respect to the health and well-being of its members. Secondly, then, the question about the issue principle. In fact, you'll see, if you look at the 2002 Criminal Justice Act and the obligations that the Director of Public Prosecutions has, for example, in producing code for prosecutors, how that mirrors to a very large extent the obligation to produce a code of ethics. So the point that you make in relation to PSNI might very well be made on one view with respect to the PPS. In fact, the point to emphasise is the interlocking nature of all of this, and the point that Section 8 guidance, and I'm not making a vulgar party political point here, simply to remind Mr. McGuinness, of course, that Section 8 was an SDLP proposal in the House of Commons.
That's you over the left. House by your own.
There's no vulgar political but it's worthwhile to have that. The points being made to me more than once, in fact, by the Advocate General along those lines. It's complementary with the Human Rights Act obligations, which are directly effective as a matter of domestic law. This brings to bear a much larger range of international human rights standards, which Parliament obviously thought were important potentially to bring to bear, not as directly effective in the same way that Section 6 does, as Mr. McGuinness knows, but in terms of the requirement to take them into account. So, at this stage, it's worthwhile bearing in mind the point that the Chairman has drawn out, that this is simply creating the potential for guidance to be produced. If, for example, having got to this step, the committee then consider that any particular piece of guidance that I might bring to it served no useful purpose, well then I don't think the committee would be slow in telling me that.
Yeah, but I mean, I think that's the nub of the problem here. I think both the Policing Board and police itself and around this table, we're struggling with trying to see the added value, as I put it.
But it's very simple. Yes. I think it's very simple because there's the concrete instance of a piece of guidance which benefits every other criminal justice organisation except the police. The police are, in many ways, on the front line in terms of the risk to personnel, and yet they don't obtain the benefit of this guidance. Secondly, the obligation, both on the police and on the policing board, is focused exclusively with respect to the Human Rights Act.
Yeah.
Section 8 scope is much broader. And thirdly, Section 8 contemplates, I think, that guidance will be produced that's relevant to the police. The obligation of the Chief Constable to have regard to the content of the guidance when producing his code speaks to that. Of course, one asks rhetorically, but I hope with more than rhetorical effect, how can that be done unless PSNI is added to the list? Because there'll be no guidance relevant to his organisation unless that's done.
You just finally, you have said the example of the forensic science and laboratory and service and the PPS, but are they not in a different position with respect the police were accountable to the policing board and so forth? That puts the police, I think, in a different position vis-a-vis the PPS and the forensic science service, which is in a clearly different position.
Well, no, it cuts both ways because it could be argued that in many ways one needs it less for an organisation that's subject to direct political accountability, such as, for example, the Northern Ireland Prison Service, which is tucked away within DOJ, and therefore, if, for example, the committee raises something that's of concern, the Justice Minister is in a position to remedy that pretty swiftly and directly. The police, of course, as we all know, have operational independence, and that's why there has been created a sophisticated system of monitoring and control through the policing board with the delicate composition that body enjoys. But where in Section 8 I think you have the opportunity to provide guidance which goes further and complements the Human Rights Act, it seems to me a natural step to take, particularly when Section 8 itself plainly contemplates that guidance will be produced that is relevant to the operations of the police, which can't happen unless PSNI is added to the list. And in that context, again, worth bearing in mind that the Advocate General and the Police Federation both support that move.
Thank you very much, Chair.
Okay, far from me to want to advance an SDLP policy, but and I know the policing boards are often seen as a sacred cow, if I can call it that in a political sense. But just to be very clear on it, in no way would this diminish the role of the policing board at all, because the correspondence that I've read indicates to me that they're being particularly precious, but without substantive reason. And I've obviously had conversation with my own colleagues who actually chairs the performance committee that seemed to raise these objections in the first instance, and he's now reassured about this after I've had contact with him. But I just want to be very clear that this does not one iota impact upon the functions of the policing board to operate the way it has been doing heretofore.
No, Mr. Elliott jocosely suggested earlier that I was less than precise in one of my answers. Uncharacteristically, he also suggested, let me be absolutely unambiguous. Chair, your summary is entirely correct. This will not detract one jot from the important responsibilities of the policing board in relation to the Human Rights Act. Absolutely.
Okay, well, thank you very much, Attorney General, for coming to the committee. Much appreciated.
Very good, Chair.
Okay, members, that indicated obviously when we discussed this on the 16th that at this stage without prejudice, obviously, to what guidance may come forward. That may be an issue for us, but in terms of the principle of adding the PSNI to the list, whereby guidance could then be drawn up, we as a party are content for that to happen. So are parties in a position to indicate, or are you wanting to come back to?
We need to come back, Mr. Chair, after the day's happened.
Chair, can I just ask, it is an issue for the department, it's not the policing board. I think I asked this before, actually. The decision of whether they're added to the list is a matter for the department and not the policing board, is that right?
Well, maybe the clerk wants to, in terms of procedurally, how this would be taken forward. It would be initiated by the Attorney General, as I understand, in terms of adding it to the list.
We can check, but my understanding is we need to change the legislation, and I'm not sure. I'm not even sure it comes through here. It may well be changed in Westminster. I don't know. I need to check, but it's a change to Section 8, so to add it on, I'm assuming. But we'll double check for you, but I think it's a change to legislation.
Yeah, Chair, could we have that maybe before we come back next week? And also, if it is the department remit, and is the policing board only a consultee?
Yep. We can do that, and then we can try and get a definitive position, if possible. Okay, thank you. Okay, item 6, review of legal aid for Crown Court proceedings. Officials want to come forward. The department's required to conduct a formal review of the levels of the prescribed fees for legal aid in Crown Court cases at least once every 2 years. At the meeting on the 27th of June last year, the committee considered proposals by the department to undertake a 16-week consultation on a number of options to reduce the level of legal aid fees for work on cases in the Crown Court. Options in the paper had been developed following work carried out by the department, which concluded the 2005 rules do not represent value for money and should be amended downwards. The committee agreed that it was content for the consultation to take place and that we would consider the matter further when the results were available. Officials are here today and they're going to outline the key issues that were raised during the consultation process. The papers are on pages 47 to 114 of your meeting folder. So let me formally welcome Mark McGugan, Head of Public Legal Services Division, and Nigel Hamilton, Criminal Legal Aid Policy Advisor from the Legal Services Division within the department as well. So you're both very welcome to the committee, and we'll record this by Hansard and that'll be published in due course. So let me hand over to yourselves to take us through the paper.
Thank you very much, Chairman, for your introduction. I have recently taken over as Head of Public Legal Services Division in the Department of Justice with responsibility for the reform of legal aid, and I look forward to engaging with the committee on this important issue. The purpose of our visit to the committee today is to provide an interim report on the outcome of the public consultation in respect of Crown Court fees and to outline for the committee the steps which we are now taking to finalise our proposals. The committee will recall that the department has a statutory obligation to review Crown Court fees every 2 years. The review was undertaken in the first half of 2013. Part of that work, we carried out a comparison of the fees payable in the Crown Court in England and Wales. We found that the fees paid in Northern Ireland were considerably higher than in England and Wales. Our consultation document contained several proposals to bring our fees into line with those elsewhere and to improve value for money. In addition, we made proposals for reform of the fee structure for guilty pleas. The consultation finished at the end of October, and in total we received 25 responses. It would be fair to say that our proposals were not universally welcomed by the professions. In their formal responses, they rejected any reduction of the Crown Court fees at all.
Understatement of the century.
They challenged our comparisons with England and Wales, claiming that they were fundamentally flawed. And they indicated that if the guilty plea too were to be removed, it needed to be replaced with some other form of payment. They argued that the fee reductions would have an adverse impact on individual legal practices. Clearly, there is a need to bring the legal aid budget under control. While Crown Court fees have been reduced, the costs are still too high. We do not accept that our comparison with England and Wales is flawed. as we took a representative sample of the cases in Northern Ireland and compared the fees paid by the Legal Services Commission with the fees which would have been earned had those cases been run in England and Wales. I would be happy to say more about this should the committee wish. Since the closure of the formal consultation, we have engaged bilaterally with the Law Society and the Bar Council. Our aim is to get a better understanding of their objections and to hear their views on the options in respect of guilty pleas. We were keen to ascertain if there were any areas on which we could reach agreement. Those consultations have been constructive and productive. The Law Society pointed out to us that a large proportion of the difference in solicitors' costs with England and Wales can be explained due to the long-established practice that solicitors attend counsel in the Crown Court in Northern Ireland. This is not now the case in England and Wales. In addition, they asked for consideration to be given to reclassifying a range of offences where fees do not currently reflect the seriousness of the offence. For example, aspects of affray, hijacking or causing death by dangerous driving. They also asked us to consider or to target fees where cases were prepared for trial but do not subsequently proceed, and to consider how best to address the issues around the guilty plea to fees. The Bar Council were concerned that further cuts were being made so soon after the previous reductions. They suggested that the comparative analysis with England and Wales was flawed and expressed concern about the potential impact of the removal of the guilty plea to fees. We've taken away the suggestions from our engagement and we're currently costing up some options and revised proposals. In doing this, we are keen to ensure that once the necessary cost reductions have been made, the remaining resource is targeted at areas where the greatest cost is incurred on behalf of the legal aid client. It will take us a few more weeks to work through this material and to develop our thoughts into costed proposals. I recognise that the committee will be very interested in our firm proposals for the next steps in our reform of Crown Court fees. However, given that we are having a constructive engagement with both branches of the profession, we consider that it is appropriate to continue while we are making progress. I would not say that it will be possible to reach agreement in all aspects, but it will be important that where possible we take account of the representations made to us. And the report which we table gives an outline of the key aspects coming from each area of the consultation.
Okay. Thank you very much, Mark. Look, very quick questions. The 213 cases that were used, what was the criteria in terms of picking the cases? That's something the Bar Council have raised, that they're not representative necessarily of the work that they're involved in.
213 cases represents 20% of the cases which went through the Crown Court in that particular year. And we tried to get a cross-section of all of the cases which would be heard, starting from those which started with a guilty plea right through to a full trial. The Bar have raised that issue with us, and we have shared all the material with them, and we're planning to spend further time with them to explain how the particular cases involved and how the comparisons were made with the fee structure in England and Wales.
Okay. In terms of the level of savings that have been derived from the changes that obviously led to the strike at one point, or withdrawal of services, I think they called it, the indication seemed to be that the department underestimated how much has been saved, and actually you've achieved more than what was expected. Is that correct?
It's not my sense, Chairman, in relation to the savings which have been delivered already. They take a period of time for those savings to work through the system, and we won't actually see the full impact of them until 15-16, by the time all of the cases have worked through. In particular, some of the very high cost cases have worked their way through the system. But I don't think our estimate of the savings which would have been delivered from those original changes to the structure is any different from what it was at the time they were made.
One of the examples gave to me was the reduction in 2 counsel and the changes that came through in that is reduced now from 55% actually now around 10% of cases, and the £500,000 anticipated saving is now actually £2 million.
That figure has been quoted to me as well, and we haven't gone back yet to test the accuracy of it. We think that if you take an analysis at a particular point in time, it may well have shown that in a series of cases at that point in time that there were 10% of them had two counsel rather than the figures which we were looking for. But I think you need to look at it over a period of time rather than at a specific point in time, and I think it's closer to the estimate that we made, albeit that for certain at certain points in time it might have come out at around 10%. We'll be checking that figure through and analysing it as part of our further work.
I suppose that bears a degree of the evidence as to why the legal profession seem to be confused, why this review now, whenever the levels of savings still hasn't worked through the system to give the department a very clear picture that this is actually how much criminal legal aid is being spent, and therefore why this review now?
Well, first of all, there's a statutory requirement on us to look at them every 2 years, and that was what we were engaged in when we started this process. And looking at how the fees are applied, the new fees are applied in particular cases, I'm making comparisons with elsewhere, was a solid way of doing that, at looking at the cost per unit as applied to the new fees rather than looking at the overall costs of the system, while the new fees and the old fees work their way out of the system. And we think that's a very firm basis. But there's a statutory requirement for us to do it, and we see the length of time that's involved in delivering savings from the system as the cases go through. So we need to plan ahead for future cost reductions at an early stage.
Okay, and finally then for me, you don't have any final proposals yet, and that engagement with the representative bodies of the legal professions ongoing. So do you anticipate revised proposals from what initially was in the paper, or whereabouts are you in that discussion?
We anticipate some revisions. We've certainly had some good representations, and we have a very positive engagement with both branches of the profession at this time. And as I said at the outset, we aren't going to come to complete agreement on this anywhere. But what we're trying to do is to narrow the areas of disagreement. And they've made some very valuable points in terms of ensuring that we target the remaining resources to the areas where the work is done, and that by some of the steps that we're proposing to take, we don't have inadvertently have unintentional consequences. So we're looking, for example, at around the GP2 fees, what comes in behind that, and at some of the areas where they've asked us to look at changing the classification of the cases and the fees which are paid because of the seriousness of them. Okay. And I think we're costing up, there's a lot of material to go through, we're costing up those at the moment, and over the next few weeks, by the end of March, I would hope to be in a position to be bringing forward final proposals.
Okay, thank you. Mr. Dixon?
Thank you, Chair, and thank you for bringing an update to us, and recognise that the discussions are ongoing at this stage. Just in your original brief to us earlier on, you made reference to a comparison between Northern Ireland and England and Wales, where you said that in Northern Ireland there was I think you said solicitor and counsel working together on a particular level, yes, compared to a single person operating that in Wales. How much of an impact does that have on costs in Northern Ireland? And I suppose the other side of that question is, what impact would it have if we, for example, reduced to the England and Wales model? Would that be a deficit to the justice system?
Well, and that's a very important question, and one I think that we need to analyse carefully. In relation to the first part of it, I think we were projecting savings on solicitors' bills of around, or projecting the difference in cost at around 43%. We suspect that, we suspect that around 18% of that difference is down to solicitors attending counsel in court in Northern Ireland. We think it's important that we analyse carefully the impact it might have of removing solicitors from attending counsel in Northern Ireland, and we're at an early stage in that. And the implications, for example, could be that there would be delays in course, in cases running through court, because the solicitor wasn't there, there would be potentially additional workload on barristers. You could potentially run into further adjournments within cases. And having identified that, we want to analyse the impact before we would take that step. So there are potential, as yet unidentified, consequences that we would need to assess and identify how to ameliorate before we move down that line.
Could we be in a situation? I can understand the issue of delay, but it wouldn't affect the quality of outcomes in terms of representation, would it?
No, I wouldn't think so. The solicitors support the barrister. The argument that solicitors will make is that they're familiar with the client, with the details of the client's family, the case and history and so on, and they're able to share that information with the barrister and provide up-to-date briefings on those areas. But I think it's still the quality of the barrister would still be there and going forward.
And we've no shortage of qualified barristers.
No.
Mr. McGlone.
Yeah, thanks very much, Chair. Thanks very much, gentlemen, for being with us. Could I maybe just go back to, I had a recent experience where I was with a constituent on a case where an appeal was heard by the Legal Services Commission, and I found that to be very useful. In fact, it was successful in her case. Quite a difficult set of circumstances, but without going into the details of that, is it the case that the proposal from the department suggests doing away completely with that appeal body?
With the current appeals mechanism? Yes. This is just for clarification, you're talking about the process which exists currently, where a solicitor has applied for civil legal aid on behalf of a client. That has been refused by the Commission, the Legal Services Commission, and it has gone to the appeal panel, which currently sits. The proposal is, which will come before this committee shortly, is actually and which the committee considered some consultation, and the results of consultation is to change the existing arrangements for the Commission and also for the appeals mechanism. We are proposing to close the Commission and to transfer the responsibilities of the Commission to an agency within the Department of Justice. And as you might recall, we have consulted on that, and legislation will be brought forward shortly on it. As part of that process, we are instituting what I consider to be a more robust appeals mechanism to consider appeals against decisions which would be taken by the Director of Legal Aid Casework within the new agency. That appeals mechanism, that appeals panel will be publicly appointed through the public appointments process, will be independent of the agency and will hear appeals against the decisions made by it. It will be similar to the existing mechanism, but it will be more independent, and it will be done through a public appointments process. Currently, the appeals panel are nominated, as I understand it, by the Law Society and Bar Council. In the future, that would be through the public appointments process.
So just, first of all, can you indicate to me what are the projected savings from that?
From changing the appeals mechanism or creating the agency?
No, the change in the appeals mechanism. That's where I started out from. I'm trying
there are relatively
better for this, because I'm sort of the mind, if it ain't broke, why fix it?
Oh, okay. Well, there are relatively modest savings coming from that. However, going back to the creation of the Legal Services Commission in 2003. There was a requirement at that stage to introduce a new appeals mechanism. The appeals mechanism which currently operates is a carry forward, and it was an interim arrangement put in place from when the legal aid was administered through the Legal Aid Department in the Law Society. And that's why the individuals who are involved in those decisions are nominees of the Law Society and the Bar Council. That interim arrangement has lived for rather longer than was anticipated when the Commission was established. Indeed, the Commission had consulted last year on changing those arrangements and making appointments to it rather than to the appeals panel rather than nominees. They've shelved those plans because of the further plans to create the agency and to create an independent appeals panel.
Right now, that, insofar as independent, what do you mean by independent?
It's independent entirely of the agency and of government.
Are you saying that the current mechanism isn't independent?
Well, the current mechanism is a sort of a hybrid where it's nominees from the Law Society and the Bar Council, and I think some of the criticisms that we might have had from, and I think it's in direct response to criticisms by the Public Accounts Committee in terms of the independence of that. It's currently the nominees of those bodies taking decisions over the award of certificates to a client, but also through the client through solicitors.
Well, now that brings me back to the point that I'm going to make to you. In order to make a considered opinion of a case around the intricacies of the applicant or the appellant that's coming before them, I would venture that someone in that position would need to have some legal knowledge, legal expertise, and you would need to have a bit of an idea of the intricacies of the law. Now, just having gone through, this was a complex case and it needed to have someone who could cast their eye over this, and no disrespect to anyone else, I wouldn't have been able to do it. So are you suggesting that that expertise, and I would venture that it is independent insofar as they're adjudicating in the same way as a court would independently on a case and the merits or demerits of that case and the application for appeal to them. Are you suggesting that that pool of legal expertise should be cast aside, and it's not breaking the bank, they do it for, I think, just costs, that pool of expertise should be cast aside in the interests of what's referred to as another independent panel, which may not have a pool of legal expertise? It's either that or you reinvent the wheel.
Well, not exactly, and I agree with you entirely about the complexities of the cases which get to the appeals panel. They should be complex. Part of the structures that we're proposing to introduce will be to ensure that the appeals panel only gets to address those appeals which really required its expertise. And the proposal which we're bringing forward is that the appeals panel should be chaired by a lawyer and should be consisting of 3 members, and the chair should always be a lawyer. And I suspect that in many cases the panel will consist of 3 lawyers, although we've made a provision for non-lawyers with particular expertise, for example in family matters or so on, to be engaged as well. But in the new mechanism, the appeals panel will always be chaired by a lawyer. Now, are we throwing out something which works perfectly well? I think there have been some criticisms in terms of how the panel is nominated and constructed, and our proposals are that they will be public appointments and go through a rigorous public appointments process as part of the new arrangements, and they will have a length of tenure when they are appointed. So I think, from my perspective, the process will be much more rigorous going forward.
Okay, thank you for that. Thanks, Chair.
Just to try and help members, what we're talking about here is purely to do with criminal legal aid and their fees. Mr. McGraw.
No, I appreciate that.
Obviously, I know, and I'm not going to curtail you on it, and fair play to Mark for responding to it, but those proposals haven't came to the committee yet in terms of reforming Legal Service Commission in that particular bill. So today is purely around criminal legal aid and the fees associated to that. But Patsy's got it on the record, and you know what's coming. But whenever that comes to the committee, Mr. McGuinness.
Thank you very much, Chair, and thank you for your outline of the position which has been established between the department and the legal profession. And I do wish you well in your discussions. I think it's better to try and work these things through and reach agreement in relation to changes. But I would make this point to you that your basic aim is parity with Britain. That's your declared aim. Whether that works out or not is another matter. But you will be aware of the huge criticism of the way in which legal aid has been cut in Britain. You've heard of chambers in Britain, for example, Mike Mansfield Chambers, just simply being dissolved because they believe that they cannot work under the new system, and that the system in Britain has come under considerable criticism from the judiciary in Britain, not least the Lord Chief Justice. Now, is that the sort of service that you want to give to the people of Northern Ireland?
Absolutely not, and I don't think what we're suggesting is actually parity with England and Wales. England and Wales, there are quite different systems operating in the two jurisdictions, and while it's helpful to do a comparison of value for money terms, we need to then apply those arrangements to the particular circumstances that we've got in Northern Ireland, and that's what we've tried to do. We did the initial comparison. We did suggest, as part of the consultation, that we introduce the English system with graduated, which is a graduated fee scheme. We didn't get any take up on that. It's considered to be extremely complex in terms of operation, and I would echo that with our comparison with the fees of the cases that we looked at in the Crown Court. It is complex. However, we have to be alert to issues of cost and cost effectiveness within the system as well. And what we're seeking to do is to bring the costs down and to target and direct the fees appropriately to where, as somebody in the Bar Council referred to the other day, as the heavy lifting, where that's actually being done. So to sort out any of those anomalies, to look at the seriousness of particular offences and make adjustments where that's appropriate.
But you will accept that in 2011 we had a new dispensation, as it were, introduced in relation to costs. For example, the very high cost cases, they were effectively abolished. You also had a very significant reduction in the standard fees. That was in the region of, what, 40% or thereabouts?
I believe that's the case, yeah.
Sorry?
I believe that's the case, yeah.
Sorry,
yes.
About 40%.
I think that was.
So the standard fees have been reduced by 40%. The very high cost cases have gone. The exceptionality has been removed, and provisions were introduced to reduce the number of counsel in criminal cases. Instead of having two counsel, you'd have one counsel and so forth. And there has been a very considerable reduction there from, I believe, 50% down to 10%, where you would have one counsel dealing with criminal cases in the Crown Court.
That percentage figure has been presented to us, and as I said earlier on, we're looking at exactly what
the you wouldn't disagree that there's been a reduction?
Absolutely, there has been
a significant reduction.
There has been a reduction, yes.
A significant reduction.
I guess it's significant, but I'll come back to you on that point.
Right. Okay. And given all that, are you saying that there have been that? Given all that, what would you estimate would the savings be in relation to criminal legal aid?
Since those
2011, yeah.
Well, as I said in response to a question that the chairman asked, it takes a while for all of the savings to work through the system. I think at that stage we were estimating a reduction of £18 million. Yes. That won't go through fully until 2015-16 year. So there's been a gradual reduction. It's difficult to actually assess precisely the reductions since that time because of some steps which have been taken to reduce the backlog and the additional Crown Court judge which has been operating in Belfast over the last period of time, which has increased the throughput. So the overall figure has gone up rather than gone down. But the trajectory and looking at the cost per case is on its way down, but we won't see the full effect of the new fees until about 2015-16.
Yeah, the figure in terms of legal aid in Northern Ireland, the expenditure in Northern Ireland, criminal legal aid expenditure in Northern Ireland 2012-2013 was 31 million. Now, do you agree with that figure?
No, I don't.
Why not?
Because it's not right.
Well, tell me how it's wrong. These are the published figures, are they not?
Well, there are one set of figures which were showing in the Legal Services Commission's annual report. If you read further into the report and see the figures at the back of the report, when provisions and other issues are taken into account, the expend that year was more like £48 million on criminal legal aid.
So, whenever they publish a figure of 31 million, you shouldn't actually accept that figure?
No, you have to read it in the context in which it's been written, I think.
Can I just stop you there? If somebody says, look, expenditure is 31 million, there it is in the report, am I not being reasonable in saying, yes, that's the figure that's been expended, that's the amount of money that's been spent?
I would suggest that you are being reasonable, and yes. I would suggest that particular figure, in the context in which it was written, is a bit misleading. It misled me as well until I got it clarified.
Right. So, once again, we look at the Legal Services Commission, we look at their figures, and we cannot depend on those figures as being accurate as far as the legal aid expenditure is concerned.
Well, I think if you look at the totality of the report that figure was taken from, yes, the figures are 100% accurate. It was the interpretation that was placed on that figure, I think, which could be misleading and I guess not necessarily terribly helpful.
Yes. So, how then do we move forward in a situation where the figures keep changing? Figures being published by the Legal Services Commission keep changing, where we have estimates or guesstimates, and we have no seriously reliable figures on which to base any sort of reasonable evaluation of the system.
I think that we do have reliable figures in terms of the actual spend across each of the court tiers and across each of the types of legal aid which is being spent in each year. That we can, there are reliable figures to say precisely what they are. It's slightly more problematic in terms of forecasts, and we've taken a lot of work to develop the forecasting model.
Well, maybe just deal with that. You're saying, yes, we've had these cuts of 40% in standard fees. We've got the very high cases removed. We've got exceptionality removed. We've got provisions for the number of counsels in a case dealt with, and there's been a significant fall in the number of counsel involved in cases. We still cannot see the full working out of that in terms of savings, because there's so much of a backlog in terms of cases, and there's additional work generated by the fact that they're trying to deal with a backlog in Belfast and so forth. So, although there are hidden within these figures savings, those savings aren't actually being presented to this committee or to the public at large. And you're saying, well, we'll work on forecasts, etc., but we still want to go ahead with further reductions in legal aid here, despite the fact we've made significant advances. I mean, that is not a reasonable position to adopt, and not a reasonable position to give to professionals working in this area.
I think you've made a number of points in there in terms of steps which have been introduced already to deliver savings against the legal aid budget, and also the fact that we are aiming at a moving target. This is demand-led. Legal aid is a demand-led service. You're also aware that it takes a period of time for cases to work through. So when the new fees are introduced, they're not applied retrospectively to the existing cases in the system, but they apply to the cases which come into the system after that, and for which legal aid certificates are awarded after that. And yes, there is a period of time in working those through the system. If we hadn't had the increase in business as a consequence of the additional Crown Court judge and other steps which we're taking, and which are to be welcomed because they reduce the backlog and reduce the delay in the system, there would be much more. There would be greater clarity in the trajectory of the figures going down, and we can do an assessment of the cost per case and to see that reducing over time as well. We haven't got that analysis in front of you currently. However, we need to prepare, and I think that you've just made the point entirely effectively, that we need to prepare now to look at further reductions to live within budget in the years ahead, because it does take that period of time for the cases to wash through the system and for the new fees to be applied.
Yes, but the point I'm making, Chair, I'll finish now. The point I'm making is you're looking for reductions. If you got your way, you want to see a reduction in fees of 45%. That's under option 1, 45% for solicitors, 30% for barristers, and then in relation to option 2, you want to see a reduction in fees 45% for solicitors, 46% for junior counsel and solicitor advocates, 31% for lead junior counsel, 20% reduction for leading junior counsel, 29% reduction for Queen's Counsel. So you're looking for very hefty reductions by anybody's standards, right? And yet you are premising that on figures that are altering by the month, not just simply by the year. We're in a position where the Legal Services Commission doesn't know where it is in relation to the spend on legal aid. And yet we're working on these figures. You've got significant reductions already in 2011, and you're saying, well, by the way, to the legal profession, we want cuts of an average cut of, say, 30% or 40% in addition to the 40% you've already got. I mean, surely that is very unreasonable and very unsatisfactory.
Well, we have explained in cost and value for money terms and cost effectiveness terms how the fees which are currently paid in the current schemes in Northern Ireland compare with the fees which are paid in England and Wales. We've identified some of the differences as a consequence of that, and as Mr Dixon raised the issue of solicitors attending counsel in the Crown Court in Northern Ireland. If that was removed, that's actually a piece of work which isn't done anymore. But and that is a significant proportion, as I explained, of the difference between the two jurisdictions.
Yes.
Now, we're looking at that and examining the implications of it before any final decisions are made in respect of it. But that represents one big area. The other bit is in terms of how the fees are actually calculated and the level of remuneration and targeting that available remuneration at the appropriate places.
Well, I understand the latter point in terms of tweaking and trying to maximise points here and there, and on the guilty pleas and that sort of thing. I think there's a reasonable case there. But just overall, in looking for these massive reductions, having got a previous very, very significant reduction, I think it's a very hard proposition to fully understand or be sympathetic to. And just a final point, maybe more by way of comment, I've been lobbied by quite a number of solicitors' firms doing criminal defence work. These are not big firms. Some big firms, but largely small firms. And they're saying, Chairman, we will go out of business, or alternatively, we will have to lay off staff, both ancillary staff and professional staff. I think that if you get to that point, you're actually damaging the sort of legal service that we are proud of here in Northern Ireland, and I think that would be to the detriment of everybody. I put that point to the officials because really I don't see any evidence of any work being done as to the actual impact of these cuts on the firms. In fact, the minister in the Assembly has said from time to time he's not concerned with the impact on the legal profession, and he just adopts a laissez-faire attitude to it.
Well, we'll keep the comment hanging and go on to other questions.
Okay.
Mr. Gardner.
Okay.
Thank you very much. Thank you very much for your presentation. I take it that you've taken over from Robert Crawford.
I'm afraid so.
Yeah.
You're going to have to look at me now for a while.
Don't sound so pessimistic. I mean, the backdrop to this, and I mean, Alban has already said it, but in terms of when you come at this, from your particular brief, is there a sort of wider analysis done of the impact of the reduction in fees?
Yeah, we do as much as we can in relation to that. There is a potential that some of these, if you have a single solicitor who operates entirely a practice on criminal legal aid, it may well be that there are challenges associated with that. And it may well be that people have to look at their business models and change them somewhat. Our aim is to get the legal representation and the funding for that legal representation to the clients who actually need it. In the consultation document, yes, we did a partial analysis based on the information that we've got. We invited the representative bodies to provide any additional information which they could, and certainly we've had the anecdotal stories that come back and say it is going to have an adverse impact on people. We're going to be laying people off. We haven't got any detailed information on which to make any further assessments, and if that's available, we would welcome it in order to make the assessment, and we've said that to the professions.
Yeah. And then on the other side of impact, I mean, that some of these changes that are proposed are not exactly the same as England and Wales, but you can see the trajectory. So the Lord Chief Justice in England has raised concerns about the quality of service. Is that part of your remit, or are you? I mean, if I can put this in sort of very broad terms, the department spends so much money on legal services. Though it's usually given the task, they say if it's X amount, we need it reduced by minus Y, so to speak.
The particular focus which I have currently is on reducing the legal aid budget, but at the same time with the target to not reduce access to justice, but if possible to increase access to justice and improve that. And I think that some of the comments which we've been hearing from England and Wales are in the context of the further set of reforms which are being, and cuts in legal aid which are being proposed there. Our reforms don't do that. They're based on, the comparisons are based on what's currently being paid there.
But right throughout this, I think we sort of would have said it a couple of times when Robert Crawford was in your position, but at times you don't get the full picture. It's nearly, in the past it was a high cost trials, now it's a particular aspect, family law, civil legal aid, and it would be, I think we've asked for it before, and I'm not saying it's an easy task, but if you get that full picture, then it allows us to get a better sense of that wider impact and quality, because, and the reason why I say it, because, the legal profession here have been accused of many things at this particular committee, but quite recently, and again this is in terms of budgets, there was a solicitor's firm stated very openly in terms of hearing cost trials. The decision by either the department or the PSNI to challenge every case was needlessly spending money on legal fees. So when people are coming and saying we have to cut no legal fees, and then in the same breath people are, and we've had it round the houses here in terms of the hearing aid, because the department said the best advice was to challenge every case rather than a class action. It's now turned out that might not have been a wise decision.
I'm pleased to say that didn't affect the legal aid budget.
No,
but I understand. I understand. I mean, I understand the point that you're making.
It affects the budget of the department.
Yes.
Yeah. So, I mean, if the department was operating in a leaner budget and better managed, then legal aid might not come under the same scrutiny.
Well, the budget has been set for legal aid, as we know, and we have consistently breached that budget since devolution, and we're taking the steps to
and one of the criticisms made that the budget has always been under-projected, and I think at Robert's last appearance he said that you are now going to try and do it in a more efficient way, because it's accepted it was never really properly ever
I think,
forecast.
I think that, and certainly what I've taken over is improving the forecasting model.
Yeah.
To determine the requirement. An improved forecast won't actually increase the budget. It'll just give you more confidence about how far short you are.
Yeah. It doesn't look as it doesn't. I mean, in the past, the big argument would be, here we go again.
Yes.
We need more money for legal aid. And that might now. I'm not saying that there's a pressure on the department in terms of its budget, but I think it was accepted that sometimes the forecasting was poor, so therefore every year it looked as if you were looking more money rather than having a better forecast.
And we will have by April of this year a new methodology in place. Now it will take a bit of time for all of the information to work its way through that methodology, but there'll be incremental improvements in the forecasting requirement.
And when do you think you'll have a better idea of the reforms you did and what it has, because I mean the exchange between yourself and Alban in terms of what's printed and further search says it's not quite like that. We didn't see £31 million savings, and you believe it possibly? I mean,
but £31 million was spent was the figure which was quoted there. We can do a piece of work on that and come back to you. I mean, with me coming in and taking over up this role now, it provides an opportunity to look at the totality of the programme that we're involved in, and then to refocus that. And if it would be beneficial to the committee, we could probably bring forward a paper which sets out where we plan to focus our efforts and what we're trying to achieve with that over the next 12, 18, 24 months.
And could you even reflect on what you've already achieved?
That would be useful to do that, yes.
Okay, Chair, thank you.
Ms McCauley.
Thank you, Chair, and thanks for the presentation. It's just, I suppose, to go a wee bit beyond what Raymond and Alban were laying out, and if you continue to reduce the legal aid budget, then it will have impacts on firms of lawyers, firms of solicitors, people who do the work, in terms of the quality of work. The next bit of that is how it impacts on the people who need the legal aid, who might end up victims of bad, legal decisions, imprisonment, maybe falsely, and many of whom are already very vulnerable. And it's those kind of impacts that I'd be very concerned about. And people have talked about miscarriages of justice then, and maybe the cost of remedy and those kind of decisions.
I think those are all potential risks in any reform that you're looking at, and when we're trying to reduce the cost of the system and ensure that everything remains in scope of the system. You're looking at the unit costs and trying to drive them down. Our assessment is that it shouldn't impact on the quality of representation that people are able to get. Certainly some of the things that Mr McGuinness was referring to in the earlier changes, where you're reducing the number of counsel and only awarding senior counsel in the most serious cases where they're required. That's about targeting the resource at those most serious cases, and that will continue to be the case. But there wasn't anything in our analysis which would really demonstrate that there would be a diminution in the quality of service being given to individual legal aid clients. And I guess that's something that we will need to keep under consideration as a new fee scheme rolls out over time.
I find it difficult to actually see how there wouldn't be a diminution of service provided and quality if you're going to reduce the budget by significant amounts and seek further cuts. Like the third time, somebody has to suffer. That's my view.
I think what you have to look at as well, though, is not just in terms of overall budget, but the actual unit cost, as Mark has referred to. The cost of a case here is twice as expensive as it is in England and Wales, and that's even including the cuts that we made the last time. So, although budget is an issue for us, what the exercise that we did looked at actual cases in the system and looked at how those would be treated in England and Wales and looked how they would be treated here, and it's still twice as expensive. And I think for a taxpayer, that's still a question that is worthy of exploring further.
And I think just to extrapolate on that, what you're saying is that in England and Wales, at those fees, people were getting the appropriate level of representation.
Well, we'll just have to wait and see how it works out. Thank you.
Okay, thank you. Mr. Wells.
I'm sure the people of North Belfast have risen up to a man and lobbied Mr McGuinness that this is a terrible situation, that solicitors and barristers and QCs are having their pay cut. And I know maybe North Belfast is rather different from South Down, but I must say I'm getting a slightly different reaction. I did spend a lot of time in court recently for various cases, and I was approached by many of the legal profession. I had full and frank exchanges with them, and I think you're right, there is a slight difference of emphasis between yourselves and the legal profession on this issue, a slight divergence of opinion, should I say. But can I ask a question? If we were to bring spending down to the same level as the rest of the UK on legal aid, how much would we save if we went like for like on all cases?
I don't know that I've done that calculation, and perhaps I could bring it back to the committee.
Because I cannot see any rationale, having done this analysis of over 200 cases. A criminal is no less or no more guilty in Basingstoke than Belfast or in Luton or Londonderry. So therefore you're dealing with similar sets of circumstances, a similar need in terms of adequate representation and a similar legal situation. I don't understand, now we've moved on to a more peaceful situation in Northern Ireland, why we should still even be considering a higher tariff in the present situation. Was that ever considered, that we'd simply have parity with the UK, rest of the UK?
Well, the systems are different, the way in which they operate. And for example, in England and Wales, they would have a broader range of cases that go to the Crown Court. In Northern Ireland, as Mr McGuinness will be aware, a lot of those cases would be heard in the magistrates' court. So you can't really just lift exactly the structures that they've got, and there was no appetite for that in the consultation. The 213 cases that we took were real cases and representative of the types of cases that go through the Crown Court in Northern Ireland, and that's why we felt that particular analysis had a degree of robustness and validity in it to use to identify where savings may well be appropriate.
Right. So I rob two banks. I rob one in Lurgan and I rob one in Luton. And they both go up separately for trial. Is there anything intrinsic in doing it in Lurgan that means it's more expensive to have a fair trial and a proper representation on a like-for-like basis?
In Lurgan, you would have your solicitor attending counsel, whereas in Basingstoke, or Leeds, was it you suggested?
Luton's alliteration, Lurgan and Luton.
Lurgan and Luton. In Luton, you wouldn't have your solicitor with you in the Crown Court.
But I asked the question, would my defence be weakened by that situation?
I think it's down to, I think there's a custom and practice issue in there, and one of the Nigel has pointed out the major difference, and that is solicitors attending counsel we haven't fully analysed the impact that that would have of taking them out of the Crown Court in Northern Ireland, and we need to do a wee bit more work on that before we would have confidence about what those impacts are. And I think there are a number of consultations that we would need to have on that. But aside from that, I mean, I think the answer to your question must be no.
And do the stats show that as a result of the gold-plated system that we have here, or had here, that there's any less miscarriage of justice, any higher standard of defence? In other words, do the stats show that if you commit a crime in Northern Ireland under our system, you have a much better chance of getting off, as it were, because of the representation you receive?
You could put it a slightly different way and say, in Northern Ireland, if you are accused of a crime, not necessarily if you commit a crime, if you have a better chance of getting off, but if you're accused of a crime, is there a different level of defence? I don't know that the stats would show anything. Certainly anecdotally, we are told by the Bar and the Law Society that there would be a lower level of cases where there's allegations of a miscarriage of justice, for example. I don't have the stats that would necessarily demonstrate whether that's factually accurate.
Because that would obviously indicate, I mean, if our standards were higher because we're spending much more money, well, that obviously would indicate some justification for the present system. But if we're spending a huge amount of cash and sending it off to the Kevin Winters of this world, the big solicitors who had over £2 million in legal aid payments last year, and that is still not producing a higher standard of representation, well then clearly money's been wasted. Should that analysis not be being carried out?
We could have a look at it. I'm not sure whether it has been carried out before now, and there are differences in the system, and sometimes that sort of analysis might not necessarily throw up the sort of information that would be useful.
Well, when you take this process through, and I hope you're successful. That's my personally. I hope you're very successful. Though I don't know what sin you've committed in a previous life to be having to do this.
It was grievous.
It was very grievous. I told you to shut up black hair until you took this post on 2 weeks ago. But what I'm saying to you is that if
and I had hair.
If you carry this through to fruition, per head, how much will we still be spending more on legal aid in Northern Ireland than the rest of the UK?
There are a whole range of initiatives underway and proposals underway. We're consulting on the Crown Court, and we're at an advanced stage on that. We're also consulting on civil legal fees as well, and that is a very big exercise. And it's designed to deliver savings, but I'm not sure in terms of the comparisons of because you're talking about different bits of the system. In Crown Court fees, if we introduced the full range of savings on Crown Courts, we would probably be at the same level per head of population. Leave aside the cost per head of population and look at the unit cost of the case. How much does it cost to bring a case through the Crown Court in Northern Ireland and a case through the Crown Court in England and Wales? And we can probably do that sort of comparison. I think we had some figures in relation to the Crown Court.
The Crown Court in England and Wales, it's about £5,000 for an average case, to take an average case through the Crown Court in England and Wales. Here, it's on average about 16,000.
Well, does that not tell you something?
Well, it does. It does tell you something, but it tells you to be cautious. And I go back to the point I was making earlier on, that within England and Wales, within the Crown Court in England and Wales, they are dealing with a broader range of cases. They're dealing with some less serious cases, which in our system would be dealt with very effectively within the Magistrates' Court. So our Crown Court is actually dealing with a subset of the cases that would go through in England and Wales, and they're dealing with the more serious cases. So you would expect that sort of thing. If you want to then compare the cost of a murder trial or the cost of aggravated burglary or something like that, those sorts of comparisons would potentially be more useful.
I had pure brown hair before I started on the Justice Committee, so we both had the same effect in life. But tell me something, will we still be left with the most expensive
legal aid system in Western Europe when this is all over? Because I've seen some stats from other countries, and even the British system seems to be very generous compared to other parts of the EC.
I suspect that other costs might rise as we try and bring ours down.
Very diplomatic. The other issue, and in these full and frank exchanges I had with legal QCs and junior counsel and solicitors, they said what's going to happen is that eventually there will be the fees will be reduced to such an extent that people will stop tendering, stop offering to do the work. Now, is there any evidence that that's happening in GB? And is there any evidence in the changes that have already been implemented that people are starting to turn work away and people are having difficulty getting representation?
There's some anecdotal material and in England and Wales. I'm not sure how accurate it is or whether there's been any study into it, and we can check that out. In Northern Ireland, I'm not aware of anybody turning away legally aided clients at this point in time.
Thank you. Mr. Elliott.
Chair, thank you, and thanks for the presentation. Can you give me a definition of very high cost case? When does it become a very high cost case? I know you've ended them, but when is it a high cost case?
I personally can't. I'll see if Nigel can. I personally can't because it's working its way out of the system, so I focused on the ones since coming into post that are still there.
It was sorry, just before Nigel. There are still some in the system, I'm assuming, that aren't complete?
Yes.
The definition for a very high cost case was basically a case that was projected to last over a particular period of time, and I think I'm right in saying it was about 60 days was the figure. So if it was projected to last 60 days, it was classified as a very high cost case and it was paid under a different fee regime. I think what's interesting to note is that we only had one case last year that would have fallen into that category. And again, if we refer back to the England and Wales scenario, we would have no cases now currently in the system that would come within the definition of a very high cost case.
Quite interesting that. How were there so many then previous to this?
Well, we think that there was. I hesitate to say this system being abused, but I think it was easy to say at the time, if you're a solicitor and you're looking at a bundle of evidence, to say this case could potentially last 60 days or 40 days or whatever that particular figure was. But in the event, very often a lot of our cases don't go on to trial and they collapse at an early stage, or the amount of evidence was much less, presented at court was much less than what was anticipated. So they didn't actually fall within the category of very high cost case whenever they come to court.
Yeah, but it sounds amazing that we have spent so much money on very high cost cases over the last number of years, and all of a sudden, whenever you wean them out, there are none coming forward.
Mm-hmm. No, I would agree. It's one of the reasons why I think we had to remove the very high cost case provisions, because as I say, on reflection, when you look at the cases that are actually coming before the court, none of them should really have qualified ultimately.
Chair, would it be possible the officials could give us some written detail? I don't know how much you can do, if there's some written detail on some of those very high cost cases, or at least an analysis that had been coming forward and now don't appear to be coming forward?
It's not an issue which I'm particularly familiar with, but I would be happy to see if we can pull some material in relation to the historical position on very high cost cases, where we think we are with them working their way through the system.
Well, one other question just is around what impact have delays within the justice system, overall delays on the legal aid budget? If there's delays from the police getting a file to the Public Prosecution Service and from the PPS getting it to the courts, and then maybe the courts being adjourned on a number of occasions, what impact has that? Have all those delays?
The fees depend on the number of appearances, and there are a range of refresher fees and so on which are paid. So delay doesn't necessarily help. I couldn't I couldn't say off the top of my head precisely whether there's a percentage that we could quote to you that.
My perception would be that it would be relatively limited, because all of those delays would take place when the case was at the Magistrates' Court, where standard fees would apply.
Okay.
And it would be more a question of time in between appearances at court, rather than, as Mark is rightly suggesting, refresher fees at trial. Once the trial starts, generally it starts and it will finish.
Okay.
So I would have thought those sorts of situations wouldn't affect legal aid so much.
That's interesting, just because personally I have no difficulty with you looking at legal aid and trying to reduce that budget. But I do think the pressure needs to be kept on where there can be other efficiencies as well. For example, delays, and I know that's one of the issues that regularly comes forward to me, is that there are serious delays within the overall system, not pointing it down to one aspect. And I know there's other people doing work on that as well, but I would like to see that work being cooperated with yourselves, so that it's all coming forward almost as a package.
It's all very much tied together.
Yeah, thank you, Chair.
Okay, thank you. There's no one else has indicated, so obviously you have an ongoing piece of work that you're engaged with. I think it's just important that we get as much evidence as we can. If we can avoid having contrary views from the legal profession and the department, and just get to an agreed position, it makes our job very easy. If not, then we need to obviously reach a judgment ourselves if you bring forward proposals to do with the fees. And then we need to know for sure the evidence that we're getting, is it correct? From my own perspective, I'm not opposed to reducing the fees, but I want to make sure there's a proper evidence to do it. And obviously there's a judgment as to do value for money vis-a-vis ensuring that there's access to quality representation as well, and that can be a subjective notion. And I just need to make sure that we'll get the right evidence to allow us to take a decision. And certainly the last time this happened, there was outcry and there was uproar, and I think the legal profession didn't do themselves any good by saying then that they were at a tipping point and things were going to be disastrous, because clearly it wasn't a tipping point, and now we're hearing the same arguments again, that we're at a tipping point, and that might well be the case, and I'm not going to say that that isn't the case, but I'm just trying to make the point to both of you gentlemen. If you ask us to ultimately decide between different interested stakeholders in this issue, be very sure that your evidence cannot be challenged, because at the moment it certainly is being challenged by the profession, and I look forward to getting further information.
We, as I said at the outset, we are engaging with them. We're trying to narrow the areas of disagreement, so that, fundamentally they will be opposed to cuts and fees, and if we can get areas of agreement between us, then that will be good. And we will come to you with the evidence base. That's why I was keen to get this interim report to you, so you could see the shape of the thing and where it was going, but also to allow us to do some further work before we come back to you with those firm proposals.
Okay. All right, thank you very much.
Thank you.
Thank you. Okay, members, let's move on to the next item then, which is the Youth Justice Review, and it's the update on the implementation of recommendations. As members will know, the report was published back in September 2011. Following its publication, there was a plan for its implementation made on the October 2012. Minister undertook to provide the committee with regular progress reports. The first two updates were provided January 2013 and July 2013. At the Minister's request, the CGI, Criminal Justice Inspectorate, also agreed to provide independent oversight and monitoring of progress, and at the meeting of the 9th of January the committee noted the first CGI report. So officials are here with us now today for members' benefit. It's pages 116 to 289 of your meeting folder. So let me formally welcome Karen Pearson, Deputy Director in the Reducing Offending Division from the Department, Mary Brannigan, Director of Youth Justice Services in the Youth Justice Agency, Tony Kavanagh, the Youth Justice Review Implementation Team within the Department, and Chris Matthews, who's Head of Speeding Up Justice Branch. These are all very welcome to the committee, and this session will be recorded like the others on Hansard and then will be published. So I'm going to hand over to yourselves to make some initial comments, and then members will have questions.
Thank you.
Thank you, Karen.
We're grateful, as always, to have the opportunity to brief the committee on the implementation of the accepted recommendations in the Youth Justice Review We sent in a fairly detailed note, maybe slightly longer than we normally would, but we hope that was helpful because it covered quite a range of ground. As the committee will recall, the task of the independent team of experts appointed for the purpose was to review the operation of the youth justice system in Northern Ireland and to make recommendations informed by best practice and international norms and standards. And their report, which went out to consultation, provided the basis for an implementation plan which was first published in October 2012, and the plan set out the department's response to each of the 31 recommendations in the report and described how they would be taken forward. The implementation plan was updated and reissued in January and in June 2013 to record progress made in the intervening period. And we've published very recently a follow-up report, which we hope you have with your briefing paper, Chair. And we've also had the recent publication of the Sejuni report on implementation and progress towards that. We say that of the 45 agreed recommendations and actions identified by Sejuni, 37 have either been completed or there's evidence that substantial progress has been made. And of the remainder, 8 have shown only limited or no progress and 2 have not been accepted. We provided the committee with a narrative on each of the main action points, but in broad terms, we believe we're well advanced in a number of areas, which I'll briefly outline. I think it might be helpful if I group them into themes, Chair, and then give the recommendation numbers for the record. So the first group is the joined-up strategic direction, early intervention, funding and delivery arrangements, and the recommendations relevant to this group are 1 to 3, 23, 24 and 26. And under this group, we have a cross-government delivering social change framework in place. Substantial money has been secured to support an identified programme of interventions, and a new fund is being established to develop sustainable and coordinated interventions for the most vulnerable children and their families. The next grouping covers proportionality, communication and efficiency, and the recommendations there are 6, 7, 10, 11 and 13 to 15. And these cover the full rollout of police discretion as opposed to having to refer any offence, however minor, to the PPS. And this group, we say, has coincided with a substantial drop in children entering the formal justice system. Where that still proves necessary, substantial work has been undertaken across a range of criminal justice organisations, all aimed at making the system more significantly responsive to the children and young people who come into contact with it. This group includes work on the Youth Engagement Clinic initiative, and I think the committee's had a briefing on that, but we have Chris with us today. You can answer some questions if you wish. Clearer communication with young people and their families, driving down the time taken within the diversionary youth conference process, and establishing arrangements to ensure youth conferencing is fair and proportionate to young people and victims. We also have in this group the development of statutory time limits for youth court cases. The third group, Chair, covers custody arrangements for children, and relevant to that are recommendations 16 and 17, and we have Mary with us from the Youth Justice Agency. As recommended in the review, no child has been detained in Hyde Bank Wood YOC since November 2012. Work by both Woodlands and Hyde Bank Wood staff has ensured that the new arrangements have bedded in very successfully, we say. New legislation is required to underpin these arrangements. That process will be informed by the public consultation on custody arrangements, which addresses a range of issues, including the length and structure of new custody order, and whether children who pose a particular risk to others might ever be accommodated in Hyde Bank Wood YOC on an exceptional basis. And if it helps, I can outline the next steps in the custody consultation process. In other areas, it's fair to say we agree we've got more work to do, and generally those issues involve complex structural or systems changes and where preparatory work is first required. I can give you some examples of those, Chair. Children from the care system, recommendation 19. Looked after children continue to be overrepresented in the justice system despite efforts of the DOJ, DHS SPS and the HSCB and the various trusts involved. We monitor this very carefully on an ongoing basis, and decisions to place children in detention are challenged where appropriate, obviously. Another group where we need to do a bit more, identify an alternative accommodation to custody at the point of need, and relevant here, recommendations 8, 9, 18 and 19. This remains a challenge when the balance of needs, best interests and risks to others can be difficult to square with the immediate availability of safe, suitable and secure accommodation at the point of need. With stakeholders, we're working towards arrangements that will help align accommodation provision with accommodation need. And also in this group, movement on recommendations in relation to training in the amended aims of the youth justice system and for those operating in a single youth court jurisdiction, and these are recommendations 5 and 12. These must necessarily be preceded by a legislative process, the outcome of which we shouldn't preempt, but we are moving forward with our planning and thinking on both of these issues. The key issue, I think, for readers of the Sejini report and our progress report will be the slight difference in approach between the Sejini take on the progress we've made and our own. Want to say that the Minister was very grateful to the Sejini for their independent judgment on where we are. We think the difference in approach arises from Sejini looking at measuring particular outcomes arising from the work that we've done so far, whereas we've reported on the structural and system changes that we've made to date. But we certainly don't see any difference between the ultimate objectives between us and Sejini in trying to get to a point where we can report on specific outcomes for children in the youth justice system. So I'll finish there, Chair, and we're happy to provide further clarification or answer questions.
Okay, thank you very much. Mr Dixon.
Sure. And thank you. This is a very complex and indeed quite a long-term piece of work in terms of reviewing the whole of the youth justice delivery mechanisms. But some of that delivery is beyond the scope of the Department of Justice and lies with other departments. Can we be satisfied that that they are A, cooperating, and B, that you're robustly pursuing their responsibilities within the overall terms of the review?
Yes, I think that's right, Mr Dixon. We do rely heavily on other justice family partners and also voluntary sector, but also particularly other departments, and you can imagine health and education being key partners here.
Yes, and it's them I'm really thinking about.
Absolutely. With the Department of Health, for instance, we have embarked with the agreement of the two ministers on the development of a new joint healthcare strategy. That work's proceeding. We'll obviously bring that to the committee in due course. That work is advancing, and I think our relationships at official level with the HSSPS couldn't ask for more at the moment in terms of the cooperation we're getting there, and we're moving forward with other departments equally.
Okay. And do you think do you think you're all basically in broadly that you're all committed to the same outcome in terms of delivering ultimately families and young people that will not be in the justice system rather than having to cope with those that end up in the justice?
I think it's right to say it in that context. It's not just about children who come into the formal system, but looking at methods of diversion, support for families, and the frameworks are growing there within the delivering social change framework, and also the early interventions work that's emerging at executive level as well. I think it all has great potential to assist with our cohort of young people.
Okay, that's helpful. Thank you very much, Chair.
Thank you. Mr McGuinness.
Thank you very much, Chair. And thank you very much. I'm sorry I wasn't in for the bill presentation, but thank you for the materials and so forth, and I wish you well in your work. Just dealing with the statutory time limits, you are working on the basis of formal charging of a person with an offence to the disposal of the case. You're not dealing with what I would determine to be the actual point of interaction between the individual and the state, which is the point of arrest. Do you think that really is a reasonable position to adopt when you're dealing with a young person, you're dealing with the effect of that young person of say a prolonged period of investigation and processing and so forth? Is that really the best basis on which to proceed in establishing statutory time limits?
Sure. I mean, as you may be aware, at the minute we're consulting on a draft scheme for statutory time limits.
Yes.
This is one of the things we've been discussing with stakeholders. And there are quite a few complex issues that sort of come up when you talk about when do you start the time limit. So, for example, the most obvious thing you sort of think of is arrest, because that's the point at which someone's liberty is sort of interfered with. The issue for the system in Northern Ireland is that young people aren't commonly arrested at the beginning of any sort of investigation.
Right.
So you need to find some kind of analogue that is statutorily defined and which has the same kind of protections around it that arrest does, because there are restrictions on when you're allowed to arrest someone. But if you're going through the summons process, there is nothing sort of analogous to that. The other thing is as well that with arrest is that a charge might quite quickly follow an arrest, whereas with a summons case that you may have a more sort of voluntary attender type process whereby there's a series of discussions with the police, there is a discussion around, well, how do you approach this case? So when we were looking at statutory time limits and developing our proposals, we started to think about, well, how do you handle that difference there's two procedures basically to get you into court. One is quite quick through charge and one is relatively slow through summons. So do you create a two-tier system, in which case then creates the temptation to pick the one which is sort of more generous? Or do you find a point which is broadly analogous for both sets of proceedings? Or one of the other options we thought of, well, do you create a new statutory equivalent to arrest in the summons process, which is another thing we sort of thought about. But the issue there, and ultimately the balance we thought was struck, well, if you're trying to streamline the system and you're trying to speed things up, you may actually slow things down by creating new statutory points in the process, when actually what we're trying to do is speed things up. So in the end, when we went out to consultation, and the consultation is still ongoing, so we're still sort of taking views on this. We thought the balance was, well, we want one statutory time limit, and the point at which that it sort of matches for both processes is the point at which either a charge is handed down by the police charge someone, or a complaint laying a charge is made to the court. Now, the other thing to bear in mind there is that there is already a time limit which takes you up to the point at which a charge is laid, which is for statute barred. So the system already has a time limit. So as soon as you start investigating an offence, even if you don't have a suspect, there's a clock ticking that says, well, you need to bring charges against someone within 6 months for summary business, which sort of cases involving young people tend to be at that kind of level. So there's already a time limit there. So one of the other things we were sort of looking at, well, is it worth unpicking that as well in order to bring the time limit to an earlier point in the consultation? Now, it may well be what comes out of consultation is that we need that sort of bigger overhaul of the system, that that what we're proposing is not going to sort of have the impact that we want. But at the minute, when we sort of took it all in balance in terms of how quickly we want to move, in terms of the other things like youth engagement clinics and statutory case management, which we're planning to bring forward in the Justice Bill, we thought, well, if we at least start here with statutory time limits, get the system used to the idea of time limits in the system, and then if they work very well, then we can start thinking about, well, do we extend them in other directions? Do we cover sentencing, for example? Do we bring it forward to the point of arrest? Or do we create a statutory equivalent? So say the point where the police inform someone that they're going to report them, is that kind of thing. So, I mean, the consultation is still open. Completely understand the concerns people have, because they want cases involving young people to be dealt with as quickly as possible, and so do we. But it's a question of then whether you cause more harm in sort of bringing statutory time limits into a place where it maybe doesn't necessarily make the most sense. Is that helpful?
It is very helpful. Thank you very much, Chair.
Mr. McGlone.
Thanks very much, Chair, and thank you for your presentation. Just a couple of brief questions. The Youth Justice Review and the Prison Review commented on the unsuitability of Haidbank for the detention of children. Can you give me an update or any indication from the Department if you intend to bring forward legislation to permanently end the detention of children with adults in Haidbank Wood, please?
Yes, I can. In fact, we've just completed or closed a consultation on the new sentencing arrangements for children, taking into account the fact that the Minister had announced that there would be no more children accommodated or detained in Hyde Wood from the end of last year. So that legislation clearly will come before the committee as long as we go through the process. But that's what we intend to do, and to change the law to make it plain that children will no longer be.
And do you have a time frame for that?
Well, it will have to follow this time frame, so we're looking in terms of some time in the course of next year, 2015, I think, for royal assent. That's, assuming it goes through and so on.
Just to add to that as well, even without legislation, as Karen has already pointed out, there have been no children detained in Hydebank since November 2012, so it's really a commonality and an agreement between ourselves at the moment, which we hope to have enshrined in legislation at some stage. But as I said, even without legislation, that is currently happening.
It works well. The legislation we have allows us to do this administratively, but it does need proper underpinning, because currently the nature of our location-specific sentencing doesn't work terribly well. So it's juvenile justice centre order, WIOS order. So we need to change that structure to make sure we can actually implement this properly.
Right. Thank you for that. In regard to the Criminal Justice Inspector and progress to date, in the report for the North here, published on the 17th of December last, review and progress, they highlighted in a quote the need for greater commitment, ambition and creativity to be applied if current Department of Justice plans to implement 90% of the recommendations of the Youth Justice Review Article 2014, and concluded that just 19% of the recommendations have been achieved, 50% had limited or no progress. Now, except the report looked at progress up until September 2013, and there may have been some progress in the last 2 or 3 months. But how do you think, or can you assure or give any assurances that the commitments to meet 90% of the recommendations will be fulfilled by March 2014?
We think we're a little bit further on than the Sijini report suggests, because we have reported progress against the structural changes and the inputs you need to get to the desired outcomes. We think Sijini has looked at it from the end position. How far are we away from achieving the spirit and the outcomes that the review was actually hoping to get to? So there's a bit of a mismatch there, I think, in terms of how we've reported compared to them. But we are confident that we've made good progress on a good number, as we've outlined in our plan. The commitment's absolutely there from the Minister. He's particularly asked us to engage on an ongoing basis with representatives from the youth sector. We're meeting with them quarterly. The Minister met with them in December. We'll be meeting them again in February. We want to hear their views on an ongoing basis, and we are committed to getting the implementation plan finished.
By what date?
I think we remain with the target of March 14.
March 14.
Right, okay. Just picking you up there, I heard sort of subtle nuances there. You're not saying that the CGA and yourselves were working off two different interpretations, no?
No.
All right, sorry, I picked that up wrong. Then, in regard to the cross-departmental working, many of the recommendations aren't necessarily or invariably within your remit, your department's remit. But could you give me an indication as to how successful the working relationship has been with other departments, or indeed how unsuccessful, or if there are other departments that maybe need to step up to the plate a wee bit more?
Well, as I said in response to Mr Dixon, I think things are going well, and potential to continue to help us with the issues we face with children in the justice sector, with the Department of Health, very well indeed, and ongoing concerns, as we've said in my introduction, around the number of looked after children in the justice sector. I think that's something we need to work on with as many partner agencies as we can. I wouldn't want to be critical of any department on this. There is an executive framework for delivering social change and ongoing work and emerging work on early interventions with potential to help us with our cohort.
Well, I maybe worded you a different way. Are there any obstacles to achieving what you're seeking to achieve?
Not in terms of departmental relationships, no.
Well, that wasn't my point. Are there any obstacles? If the departmental bit's working okay, are there any obstacles? Any other obstacles?
Things such as do we always have the right supply of suitable accommodation,
Yeah.
for instance, for some of the looked after children that end up with us? That would be an issue that we would raise with other partners, absolutely.
Right, okay, thanks very much indeed. Thanks, Chair.
Thank you, Mr. McCartney.
Well, thank you very much, Chair, and thank you very much for the presentation. And I mean, I think the backdrop to this was a good piece of work. The Justice Review, and there's no doubt it was very challenging, and you can see the challenges that you have to face. So my comments are to that particular backdrop. I mean, when the Justice Review team concluded, they talked about the absence of effective leadership and giving the right priority to children and young people. And they weren't being specific to whom. Do you think that has changed in the interim, that we now have the right priority and the right levels of leadership involved in bringing this to a successful conclusion?
Yes, Tony, do you want
Yes, I think we have. I think there are a number of examples of that. In particular, I was just looking down the list of practical projects that are underway with substantial funding under the banner of the Delivering Social Change programme. Pathways to employment for young people, nurture units in primary schools, accelerating social enterprise, improving literacy and numeracy, direct family support, support for parents, play and leisure programmes being developed, and the Early Intervention Transformation Fund, all of which have substantial backing at executive level and commitment from ministers. So I think that I worked closely with the review team, and at the time I think they did detect there was an absence of strategic leadership. But at the same time, as they were doing that, I think the executive, and particularly the Ministerial Subcommittee on Children, were coming to the same conclusion as well. And I think these structures now have demonstrated that there's substantial money behind it and substantial ministerial commitment to it as well.
Okay, thank you. And I mean, obviously, the Sejani report, the inspectorate report was September, published December, and then you provided us with an update. And Karen, when you were speaking, you said that perhaps our focus is at the end, while yours is nearly what you're doing as you go along. So, I mean, I assume that somewhere you're saying there's a tipping point in the speed of progress, goes quicker. It might be harder to get a thing moving, and then all of a sudden it's moving and you come closer to conclusion. But that's not clear in your briefing document at times, because, I mean, just a general observation is that too often you have things like against milestones and targets, nothing. It's left blank, and I think it's good for us to know if you're close to if you're progressing the when you think you're going to conclude, and even in terms sometimes of status, there's the phrase ongoing, and you usually know what you're doing, so you know what ongoing means. When we read it, you're not sure what it means. So maybe that's just for the future, for the document. But in terms of the inspectorate report, I mean, how do you view the report?
As being very helpful.
Yeah.
It's an independent challenge and validation to us. We will be expecting a second report from Sejani at some point this year. Just to respond to your first point, Mr. McCartney, I don't think you can get the same rate of change across all the recommendations. Some of these changes will take longer than others to start to see the results on the ground. Trying to pick which ones to report to you on, we will take your comment on board, and we'll try and be more clear on that in our next update.
I mean, again, just in broad concept, there's no doubt delivering social change will have a good impact on what you're trying to achieve, and I accept that. Can I just ask you, in terms of the statutory time limits and the age of criminal responsibility, as they remain unresolved, what impact does that have in these kind of your work, them not being resolved?
I think statutory time limits. We're hoping to have a consultation on statutory time limits. Will close on the 25th of February, and then we'll come back to this committee with our final proposals. We have shared a draft copy of the regulations. The legislation for the scheme we're proposing already exists, so it's a case of commencing the legislation and bringing regulations through the Assembly. But obviously we'll need to report back to this committee about how the consultation went. And after we have the consultation results, then we hope to be presenting a final position on statutory time limits fairly soon after that.
And the criminal responsibility age, is that any...
We have no plans to bring anything back to the committee on that at this time.
And just as final, and I know it's been touched on previous, in terms of, you know, the sort of cross the department and obviously departments equipment, where there is a breakdown, maybe breakdown is too strong a word, but where it isn't what it should be, is there a process of addressing that? And, you know, I'm not saying you have to publicly be critical of our department, but how do you make that work if you believe that a particular department is holding you back from delivering? You know, how's that translated to us? They sort of have a view of it.
Well, I wouldn't say that we're in that position with any department at the moment. I would come back, I suppose, to the example we gave around appropriate accommodation not always being available. That just takes a process of working through with health and delivery partners. But I think it's also fair to say that we have ongoing discussions with health, both on the policy issues, but also on a practical level. If a child arrives at Woodlands and that there's a sense that that's maybe not the right outcome, those issues will be taken up in real time.
I think it's also fair to say that some of the outworkings of more partnership working, they do take a bit of time, and progress is being made in relation to goods. So I suppose we can't really report any particular barrier that if it were removed in the morning, things would move any faster. Conversations and negotiations do take a wee bit of time, but I think it is fair to note that the recommendations in the report that are solely, I suppose, under our behest have all been met and have all been implemented in full. The rest are works in progress, and we are getting there.
But if there was a barrier, there's a mechanism to address it, like be it minister to minister or appropriate level. Okay, thank you.
Okay, thank you. No other members? Can I thank you all very much for coming to the committee? Much appreciated. Thank you. Okay, members, let me move on. Item 8, results of a UK-wide consultation on EU regulation. Relevant pages is page 29. The Department is proposing to make a stat rule under powers that's conferred to it through relevant legislation to comply with an EU regulation concerning the export and import of hazardous chemicals, which will apply from the 1st of March 2014. If amendments to the explosive regulations are made by the 1st of March, then the European Commission will invoke infraction proceedings. Therefore, the Department's intention is to lay the rule, which is subject to negative resolution procedure, as soon as possible, with the aim of having the provision made by the 1st of March. It's for members to indicate if they're content with this statutory rule, which I'm advised is purely a technical procedure to make sure we don't get infraction proceedings. So the formal rule obviously coming in. Item 9 is human trafficking, the exploitation and the evidence event that is planned, and that's on pages 5 to 7 of your table pack. That's on Thursday the 13th of February. It starts at 12 noon and hopefully it'll run through to 3 o'clock. Following that then, the plan is that we will meet for a short period of time to go through the routine committee business. So hopefully members have had a chance to see it. If there's any comments, that's how it's provisionally outlined, that we'll try and run through the evidence sessions. Okay, item 10 is an update on the delivery of the Prison Service Reform Programme. It's at pages 299 to 328. There's a written update on progress to the Prison Service Reform Programme since October 2013, and a copy of the latest summary report from Prison Review Oversight Group. The next oral briefing session is with the Prison Service officials on delivery of the reform programme, which is due in April 2014. So if members are content, we'll note the current position in relation to the delivery of the Prison Service Reform Programme. I would be keen to hear, subsequent to that presentation, from the Governors Association. We've heard on a number of occasions from the Prison Officers Association, but there is a Governors Association, and I think it would be useful to hear from them as to how the reform programme is proceeding from their perspective. So if members are content, we'll invite them at a future point, but it'll be after this April briefing anyway, but we'll schedule it in before sometime in May or June. Item 11 is Access to Justice Reform Programme, and it's the Project 18, Scope Review of the Operation of Family Justice System, and it's page 330 is where it starts in your meeting folder. A committee wrote to the Department of Justice in October 2013 regarding its concern over potential slippage in the delivery of the Access to Justice Reform Programme, Project 18, which relates to undertaking work to consider how a fundamental review of the operation of the family justice system can be taken forward. The Department responded outlining Minister had agreed to the development of proposals for a staged approach to the reform of family justice, the first stage focusing on beginning to address some of the more pressing issues, including unnecessary delay in care proceedings, the development of a cross-departmental strategic approach to alternative dispute resolution services in family disputes, and the enforcement of contact orders. The Department has now provided further information that we requested on the 21st of November, confirming it does not intend to take forward a fundamental review of family justice at this time. It indicates such a review could only be taken forward with the agreement of all the departments with responsibilities in respect to family justice, including the Department of Health and Justice, and they're of the view that it's preferable to proceed with the work that will begin to address some of the issues that have been raised. So it's for members to note the Department's intention to undertake a family review of family justice at this time, that it's not doing that, but instead it's taking forward these specific projects that have been identified. So if members are content, we shall note that. That was all the other items we had dealt earlier in the meeting. Mr McCartney, there was one you wanted to pick up just in correspondence.
It was must because it was in the table packed here. It's just in terms of the spring estimates. Now, they may get a chance on Monday to ask us, but it's just in relation to spend in and around Desert Creek. If it's not clear, you know, and maybe on Monday it will become clear. But if not, perhaps next week we maybe ask the department for an update just on that Desert Creek project.
All right. Well, we can seek that clarity.
On budget.
Monday might allow you to ask the question, and the tables don't make it specific if there's anything being spent. If it doesn't come out clearly on Monday, then maybe just ask the department where I can come back to that next Thursday.
Okay. Well, we can do that. We had dealt with all of the other items earlier in the meeting because of the slight delay in the first evidence session. So that's everything complete, and then we will meet next Thursday.
This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30.